Pardon, my lord?
Were you graduates?
My lord, I was a graduate.
Then did you inform about your graduation to the?
No, my lord, what happened in this matter is that I must concede that I did not disclose this fact when the early advertisement was issued, but I was being appointed. The notification which the learned single judge relied upon, saying that as far as the High Court's notification under Article 229, I am not eligible. But the 229 is restricted only to the establishment of the High Court offices, not to the subordinate judiciary.
As per as this honorable court's order, judgment in Renu's matter, the High Courts were supposed to bring a centralized system as far as the recruitment of grade 3, grade 4 in the subordinate judiciary is concerned. In the state of Assam, that rule is pending since 2018. Now what happened is that when I raised this matter in my review, the honorable single judge said, no, High Court is right because High Court has exercised this power under 235 and 236, which is against the law laid down by this court itself.
You are not qualified.
Well,
You are overqualified.
200 odd crores. That's the
500 crores.
500.
That's what Mr.
500 crores is the difference, my lord, in the bid. Question is, my lord, would the Supreme Court give an opportunity to a man who was 500 below me, who was nowhere near the benchmark of 15? I can understand the case. I was genuinely saying, well, I didn't know there was a pre-bid conference. He could have asked. He asked other questions in the pre-bid conference. He didn't ask this question. What does it mean, my lord? You know what it means. Otherwise, the first question would have been, are you to give this security or no? Security is 350 crores. So please note, my lord, no.
He went before the court on a ground that though this condition was necessary,
It was.
he came to know after a contract was awarded to you that the contract is awarded to you without.
That is wrong.
That's what the High Court has found.
So now, my lord, if that is correct and there was a genuine doubt, he would have asked this question at the pre-bid conference. That 350 crores is a lot. Are we to give? Are we not to give? If you go below 50, he didn't ask that question. He was therefore clear in his mind and he's now twisting. Now, my lord,
Only one, there was, I know Justice Chandran's query that even that pre-bid conference was struck off. But there was another clause under which pre-bid conference did take place. He participated, asked other questions.
didn't ask this question. Now, my lord, kindly see. Sorry. Kindly turn to page 130 first. Your Lordship, nobody has shown this first. 130. Then I will go back to clause 5. What will supersede what? 130. Lord, I am in item 42. Your Lordship will have that file. I don't know, my Lord. The solicitor's file. Whatever I am showing, my Lord, is a part of the bid documents. Nothing is added, nothing is subtracted, nothing is given later. 130. See, my Lord, the last portion. This bid is governed. My Lord Chief Justice. Yeah. This bid is governed by the GTC conditions stipulated in the bid and the SLA. So it is governed, my Lord, by GTC and the SLA. It is SLA which has the scoring out. So kindly mark, my Lord. Governed by bid, GTC and the SLA, specified to this service as provided in the marketplace. However, in case of any condition specified in the GTC is contradicted by conditions in the SLA, then it will override the conditions of the GTC. SLA is therefore supreme. SLA, my Lord, has the scoring out right at the inception, which your Lordship may be pleased to see. Clause 5 is in GTC. The scoring out, my Lord, is in SLA.
No, clause 5 is not in GTC, clause 5 is in ATC.
No, it's a GTC, page 17, my Lord.
But which provides that if there is a conflict between.
I will come to that, yes. But please note, my Lord, clause 5 is of GTC. Very broadly put, my Lord, in there. Whatever is in 5, if it has a conflict with SLA, SLA will be supreme. Simple. Whatever is in GTC, my Lord, will be inferior to the SLA. If that is so, whatever is in, my Lord, page 17 will be inferior to the SLA. SLA has the scoring out and therefore there is no confusion. Straight and simple. Now come to page 17.
17.
Once he has, Lord, of the improved judgment. Paragraph 50. Clause 5 of the, page 17. Actually, my Lord, the discussion should stop here itself. Clause 5 of the GTC states below. Now pause here, my Lord, before I read. At page 130, SLA is superior to GTC. whatever is stated in the GTC will be subservient to the SLA. SLA has the scoring out. Therefore, we don't need to go further. SLA has the scoring out. So, my lord, why should we read, my lord, this? That's the error of the High Court in looking at this versus this versus this. That also I will demonstrate is wrong. But, my lord, the discussion according to me should stop at reading page 130 and para 5. Because if GTC is superseded, my lord, by SLA, SLA has the scoring out. My lord, the Chief Justice asked a very important question last time. Was the scoring out, my lord, later introduced? Or was it a part of the bid? Yes, that's very important, Lord. If it is later, it will create confusion. But it is a part of the bid. Why? My lord, these are template agreements. They are meant to apply to hundreds of contracts. And therefore, my lord, you have to score out some, add some. For example, solicitor said there is no STC in this case. There would be STC in another case. So it's a template agreement. Now, my lord, if anything which is stated in 5 is inferior to the SLA, and SLA is to operate, my lord, see the scoring out once again at page 237. Then I will go back to my lord 5 again. No problem. Kindly turn to 237, my lord. 237, my lord, is a part of the SLA. And SLA starts at 231. My lord may see 231. Your lordship will find SLA terms and conditions. My lord, the Chief Justice have it. 231. This is the SLA. Now turn to 237. 4.6. Now this scoring out is not one line, my lord. The entire clause going on till the next page is scored out.
Yes.
Next page. Now one more thing which is important is, my lord. When you give an APS, in a given case, if you have to give APS, there have to be rules as to how long the APS will be valid, what will be the terms of the APS, right? All that is at the next page at 238, actually. Your lordship will see
These pages are 56.
on the top second line. If work is awarded with APS, so that means there can be, there may not be. It will be furnished in the form. Validity will be 1 year or 90 days. The next para. Subsequent extension will be so much. The next
That is
para.
all deleted according to you.
So all this is deleted. And therefore to insist for the High Court, say give APS. No, APS can't be in a vacuum, my lord. It has to be with these clauses. Where are those clauses? Nothing is there. The error by the High Court is not looking at page 130 that SLA will be without, my lord, the heart of the additional guarantee, which is this, to say in the air. Suppose the lordship were to say,
Yes, Ram, let me speak.
so, my lord, just one more thing. I wanted to give a copy.
Just saying it's a mistake in my friend.
I have, my lord, put those things from clause 5, if it, my lord, is necessary. Though it is superseded by, my lord, the page 130, I have just put it in a graphic form. My lord may see this. Just see the graphic form. I have, my lord, broken down clause 5. Wait, lordship, just Chandurkar. I have broken down clause 5, my lord. So, lordship needn't see clause 5 now. As per clause 5, STC which doesn't exist and the SLA which has the scored out and SLA superior by virtue of page 130. The second part, my lord, of clause 5, ATC, which is additional performance security, will be superior to GTC and STC does not exist. So your lordship will find in either of the triangles that I have made, there is no supersession of the SLA. Now see the notes, my lord, at the bottom. Hence, SLA is not superseded. Clause 4.6 at 237, additional performance completely struck off. 23.6 provides that additional will be given only if the bid is below 15, but it is struck off. And the GTC at page 130, which I have shown to your lordship, also states that SLA will supersede the GTC.
Yes.
And that is why, my lord, he never went and asked. And that is why he stopped at 13. Not the difference between 13 and 18% is 500 crores.
Why should I answer?
So he did not, my lord, these are contemporaneous, my lord, issues which show the state of mind of somebody. I don't need to ask, but I am not going to go below. When you suddenly realize, oh, that somebody's got it,
Yes.
you then start a petition on 1st of July. And the next day, my lord, the LOI is issued. Therefore, my lord, and I repeat, my lord, in order to save the contract, which I have got, the judge, my lord, with great respect, has said, the Chief Justice, that this could be for extraneous consideration. What is extraneous? Lord, we are struggling.
Where
Lordships are
the-
struggling to find out.
Where the parties made
Sorry.
in personal capacity. Where was anybody added in a personal capacity?
No, there is no argument. This is a 70-page judgment, and the judge says, "Oh, this could well be to exempt my client from DBS, and therefore it is
Another 5 days or anything.
Yes, Dr. Singh.
And I said, and therefore, Lord,
Yes.
I am willing to give that security.
Yes, that
Your Lordship will record.
direct solicitor.
Save the contract, I will give it.
Now, my learned friends have argued at some length last time and today. I will take 5 minutes for this. Every concept and fact told to your Lordship, 90% is wrong. Just bear with me. The heart of the matter, where everything falls into place, is the hierarchy of this GTC, STC, ATC. Please note down my submission.
First, whether are you willing to give an undertaking?
That was in principle, of course, without the APS being additionally matched by us, we are above 50, we don't have any APS, then we'll match the price, which is without the APS. Yes. But I'll find out.
No, not without APS. Now we are learned solicitor says,
No, everybody will follow the same APS,
Yeah.
but my matching will be of the price depending on whether I'm above APS or below 50.
no, your matching will be minimum of what is offered by Dr. Road.
Yes, of course.
Mr. Road, sorry.
Yes, of course. That's
Are you willing to give that undertaking?
but give me till Thursday or something that I have to find out. In principle, I think that's a fair point, and I've told them. But now just allow me to tell Lordship how unfair this is.
We'll interfere.
Take a chance.
We'll interfere only
I understand,
in the event you are willing to give such an
I
undertaking.
can't go beyond today instantly than saying this that I
No, you can ask your instituting counsel to ask your clients on telephone.
we are saying that if we are, as far as matching him is concerned, answer is yes. But obviously, if we are above the APS level, whatever it is, then we don't have to give APS. My learned friend was 18%.
18%, so whoever, the minimum bidding will start at 18%.
That's all. That's a reserve price.
And whoever,
That's not the point.
one
Right.
minute,
Yes.
and whoever is successful will have to give that ATS of.
I'm agreeing. I'm fully.
Whoever will be successful will give the ATS provided he's below 15%. Naturally, APS is 15%.
Yes, but now the bid will be below 15% only. It has to be not below 15%. It has to be below 18% now.
No, my learned friends are mixing up two things. No. I didn't interrupt for 2 days last time and today. It's a running commentary. That one issue is the reserve price. We are all
Now
clear.
the
The reserve price is a figure.
Now the reserve price
Is there 18.7% minus?
it would be 18.7%.
Right. That's over now.
And plus ATS.
Right. No, plus 80. Now, Malas, on that figure we all bid. Right, Malas? I bid above that. You can't have both, Malas. APS will not arise. There is a conceptual error here. There is a conceptual error. APS to make sure that people like Mr. Rodgi, who went below 15%,
Now he's
will
willing
not
to-
walk away.
Now he is willing to give that 363 crores ATS.
Now, your Lordship is having a rebid on this model of a reserve floor price. Floor price.
Of
Floor price.
Minimum price would be 18.3.
So that's a floor price.
Yes.
That has nothing to do with APS.
That has ATS also.
No, Malas, that's a figure. Let's say it's 10 rupees.
Mr. Dr. Srini, we are willing to.
We will match the floor price and
Match
bid
the
above
floor
that.
price.
And bid above that.
And plus ATS.
No, ATS will not arise, Malas. Please appreciate.
This is a common sense question
Yeah.
that anything below 15% has to be accompanied by
I came
ATS.
here,
And if it is 18% below, then the ATS will normally be there.
No, Malas, I came here without ATS. They allowed everybody above 15% to not give ATS. Mr. Rodgi artificially depressed his price.
We'll consider your case only if you are willing for minimum bid of 18.72% with an ATS.
That I've agreed, Malas.
With ATS.
Well, I am unable to. There is some conceptual error.
Then tell me.
ATS will not arise. I'll tell you why.
How will it not arise if it is if everybody is below 15%?
Yes.
Quoting more than 15% below. So he is quoting at 18%. You may quote at 19%. Somebody may quote at 20%.
See, I bid above 15%. I was not. I bid 13% less. So I was kosher. I came to this court because he did not insist on that. It is his fault that he bid below 18 and got that condition waived. So my price was never culpable.
Okay, we'll
I-
set aside the order of the High Court. If you are not willing to give that undertaking,
Let me then take instruction with ATS also. This I have taken on the first part.
you take instructions by 4 o'clock. Whether you are willing to have a minimum offset price of 18 point how much,
That I have agreed, Malas. I have agreed.
and also ATS.
Now, but let me now place the case. Very well, I'll take the risk. But allow me, because I'm now only open now.
Okay.
There are here, your lordship, of the first part we have got instructions. Second part is the extra 337 crore, etc. We'll find out and tell your lordship. Now, this is important. Lordship is uninfluenced by all this. Just see the conceptual error, because lordship is being invited to make an error in the construction of a contract which he admits his mistake. Twice he writes his mistake, and the benefit should go to Mr. Rodgi.
Yes, where does he admit that? Please?
Yes, twice. The benefit will go to him. It's only written. Please take the latest affidavit. Take the latest affidavit. My lord has given. Mr. Mehta gave.
That's board of.
Allow Mr. Mehta. Allow me to place your mistake at least. You've been fair enough to write in English
Scored in
language.
one and not scored in.
Yes, yes.
That is the mistake.
These
This
affidavits-
kind of benefit should go to Mr. Rodgi and not to have a retender, not to me. Come to para 7. He admits in black and white. The benefit should not come to me. I state that ATC. No, Chief Justice has got 7 minutes.
Yes.
I state that ATC starts at 62 and the part which is mistakenly retained is at 1024. This mistake has occurred due to the copy paste from the earlier bid. This is, just see what the mistake is in a minute. Though this condition was decided to be deleted, which is reflected in the
Now, therefore, we are saying that we are
state that for
trying to put everybody on same level.
I am on the mistake. See the next part, 8, para 8. However, mistakenly, the condition for additional performance securities accidentally remained at page 10. Twice he said mistakenly. But leave this aside. Now, Maras, the first question is, what is the hierarchy? There are 4 concepts. Just write that down for a minute. Give me 2 minutes. GTC is the bottom of the hierarchy. STC, which includes SLA, is above GTC.
Where do we get STC includes SLA?
Yes, directly here itself, when I show the page. Whereas this is in this itself. Come to whereas page para 4 top. Para 4 top. In an individual case, there may or may not be STC, but the hierarchy of SLA is that of the STC. See the top of para, second page, para 5, top whereas. Small Roman 4, my lord has got.
Yes.
Product track domain specific STC of particular service, including its SLA. Wherever SLA is there, the hierarchy is the including part of STC. This is what the High Court holds.
So you show us from the document.
Yes, yes. This is
That's
this quotation.
no. You show us from the documents on record that SLA is a part of the STC.
Whereas SLA is part of the STC is what is quoted by Mr. Mehta on the top here. Now the document itself is whereas 200 of the first file, Mr. Mehta's file. This is no. I'm on this part. Go down.
In caliber.
This is in Balas. I'm sorry, page 17. It's quoted in 17, 17. It's quoted.
Of the judgment.
Yes, quoted.
Forget about the judgment. You show us the document.
No, this is the whole thing is quoted, Balas. Contracts, clause 5. It gives you actually the whole clause.
We have already seen that.
So therefore,
Show us from the record
yes.
that SLA is a part of STC.
So just turn to para 5. Just see the structure, Balas.
The para 5 you already
Yes.
read that.
Following document
So
should be
Singvi para 5 you have already read from the.
no, shall be construed to be part of the contract generated through GEM, scope of supply, GTC, product service specific STC. That's number 3. That's my order number 3. 4. Product domain specific STC, including its SAL. With the STC goes the SAL. And then ATC comes on top. Now, Maras, on this finding, the finding here at para 50 to 53, please read. 51. Come to 51. What my learned friends scored off is the SLA.
If you are willing to bid at 18 points so and so low, along with ATC, we will consider.
I appreciate.
Otherwise,
First part, second part will come back at 2 o'clock. Because then it is not necessary to argue.
2 o'clock only 1 minute. Whether you are agreeable for that or
I
not.
will just tell her should be agreeable or not.
Yes.
But just
If you are agreeable, we will
Just-
permit everyone to participate in the tender.
Now let us just note one thing. Para 51 to 54 says, but one finding, that if ATC is the highest, there is no deletion in ATC. It is not his case, a deletion.
Yeah, appreciate that. Therefore,
That's right.
we are saying that we want to put everybody on a same level playing field.
That is a practical solution. I understand that. I am not objecting to that.
No,
That's why I agreed to the first
You are
part.
willing to file an undertaking that you will bid at least at 18 point so and so. with an ETC, we'll consider.
But my lord,
Otherwise, we'll say that.
but my lord, think of another thing also. This is virtually well as a tendering between us. This is what Lord should be saying is a tendering between us. And whatever 4, 5 other people, 9 people are there, I believe. 9 people are there.
Whoever is technically qualified. Yes.
So Lordship will be having a retender within a smaller circuit of people. That's all. Otherwise, the retender would be all
Only among
qualified people.
only amongst technically qualified persons.
Maybe
No, no, no.
give better.
So that will save the time also. Otherwise, the retendering process may go on.
At least 6.
If you are willing for that, we'll.
Keep one thing in mind, Manoj. You come and bid, Mr. Varoski bids at 18.
We'll withdraw that offer now. If you argue anything more, we'll withdraw that offer.
Very well.
We are only interested in the larger public interest. We are not interested in either your client nor Mr. Oti's client.
I immediately.
But Lord, I will be at a disadvantage.
Oh, you are.
By virtue of this,
In a bidding, you may.
it will happen.
It will be the.
I have already thought of it.
It will be the state who will be the best beneficiary.
I have already said that.
Though you were not willing to
Saving
give
money.
Maharashtra
Now he says I will bid high.
rupees. The learned solicitor fairly agreed for that.
He was saving money, now he says he'll bid high.
Anyway, my Lord, whatever the Lordship.
So, because for you, these thousands of crores of rupees may have been not relevant, but for the public spirited citizen and for the public, this money is more important. The public money, why should be permitted to be squandered away by? We don't know whether those observations made by the division bench are correct or not.
That's fine.
What discharge kar do baat mein.
Right.
2 o'clock to 2, not more than 2 minutes.
No, only to record this.
So, there is one item, my lord. Item 24. My lord, item 24, it's only for my lord, appointment of the presiding arbitrator. We have appointed our arbitrator.
Yes,
I've done for Friday.
Friday.
Thursday.
Item 31.
Item 31. There is a stay from more than 1.5 years. It's a fountain at Nagpur.
Today we can't hear it anything.
Today I am not requesting next week.
Thursday.
Next week. Next week.
Thursday, this Thursday.
Okay, Lordships, may I mention item?
Thursday is a miscellaneous and since we are not traveling, we will be sitting for the entire day. We will take up all the matters.
Well, let's fast over madam. Thursday's.
My Lords, may I mention item? May I mention item?
My lords,
item 29, if my Lords may.
Passengers on flight
तो हो जाए थोड़ी मस्ती
विंड एनर्जी, सिंपल फिजिक्स।
लाइफ में प्रॉब्लम सॉल्वर बन गए तो एग्जाम क्या चीज है? आकाश आइए और प्रॉब्लम सॉल्वर बनिए। अपीयर फॉर एंथे एंड गेट अप टू 100% स्कॉलरशिप।
Bye-bye. Tourist trapped. Hello, Pocoyo.
Hi.
Lovely day, isn't it? Pocoyo, the little alien wants to take your picture. Beautiful flowers, Pato. I think your garden has some admirers. Very lifelike. How's ballet practice going, Ellie? Yes, it's very important to stretch. It seems you have some new fans. We've seen a lot of little aliens today, haven't we? Uh-oh. They want to take a selfie with your sandwich. Look out, Nina! It's time for the green aliens to go home to their own planet. He says, "Thank you for everything." You say you all had a wonderful time? Well, that's great. Ellie says you are always welcome to visit again. But maybe not all at once next time.
Wait!
Oh, right. You want to give them a snack for the trip home. Very nice, Pocoyo. Bye-bye, everyone. Time after time before time. Hello, Pocoyo. Hi, Nina.
Hi.
Having a picnic, I see. And something smells good. cupcakes, Ellie. I bet you worked hard on them. They look marvelous. Well done. Oh dear, Ellie. And you worked so hard. No cupcakes today. What a pity. A machine that can take you backwards in time? Oh, so you can go back to before the cupcakes were smashed. Brilliant. But how's it work? Incredible! We've gone back in time a whole minute. Guys, aren't you forgetting something important? No, Pocoyo, the banana peel. We can't let Ellie slip on it again. She's coming! Hurry! Tuck in. You ate them all. Oh, I see. You'll just go back in time again and have a second helping. But, oh dear, where are we? Yeehaw! We're in the Old West. But it looks like Miss Ellie isn't making cupcakes. Well, I'd say that now we're in prehistoric times. Aha! The banana peel, of course. At last, you're back in the present, and just in time for the cupcakes. Oh dear, hard luck, guys. You're a bit late. No, wait, there's Ellie. And she made more cupcakes just for you. Bye, everyone. Bumbleberry Surprise. Hi, guys. What are you reading?
Recipe.
And have you found something tasty? Looks like you found the perfect snack. And how is it made? Oh, I see. We need bumbleberries, of course. What are bumbleberries? Ah, a special delicacy that can only be found in the amazing bumbleberry forest. That's better. I think he likes you, Pocoyo. Nina says the berries highest up are the sweetest for baking. They grow all over the forest. Maybe you should split the group in two to collect them faster. This seems a good place to start. The bumbleberries look excellent. Pocoyo, why did we come to the forest? That's it. What teamwork! See? Pocoyo has found the best berries while bouncing. You're ready to bake now. Terrific! Good thing there's plenty of friends to taste this tremendous snack. Disco Flavor. Hi, Pocoyo. Hi, Nina.
Hi.
Oh, gee, I'm sorry. Hi, Lula. No, Pocoyo. Lula's not dancing. She's scratching. But why? Ah, Nina, you know what the problem is? Uh-oh, you've got fleas. That's why you're scratching yourself. What can we do about it? It's a flea party! Their dancing is making Lula itchy, and so she has to scratch herself. That's it. You've made the fleas massage Lula instead of making her itchy. Congratulations, guys! Everyone gets a massage. And the fleas can dance as much as they want. Hack Attack. Hello, everyone.
Hi.
That looks like a fun game of football you're playing. What a great goal! Hello, Nina. Hello, Roberto. Would you like to play football too? What's that? You have a much more fun game at home? More fun than football? Nina wonders if you'd like to try her game. Why don't you run and get your game, Nina? Nina was wondering if you'd please mind her pet robot until she returns. Great idea, Pato. Roberto can be goalie till Nina returns. Roberto, you must stop the ball. Oh dear. Are you all right? Oh my. Roberto looks like a toaster. He is a toaster. I'm afraid
Please, my lords. My lords, this is an application filed in MC Mehta Air Pollution by Indian Railways. This is regarding the hoarding issue and revenue sharing. Hoarding, my lords, the advertisements, hoarding issue, revenue sharing between the Indian Railways and MCD, my lords. My lords, matter was listed last in 2021. The air pollution matter is listed before your lordships tomorrow, my lords.
Tomorrow, how many? Tomorrow, दिन में की परसों है? हाँ?
The batch.
It is वाला परसों. Well, we don't know how much matters will be in a position to take up tomorrow because there are so many that lawyers issue is also there with regard to AD summoning them.
My lords, we have it tomorrow, my lords.
Have it tomorrow, but we don't know how much matters we can take it up. That's what.
Milords, I am the.
Not to be deleted.
Milords, I have
Already deleted on 9th of September, ma'am.
Milords, I want an early date because of urgency.
How can it be earlier now?
Milords,
Tuesday onwards we'll be sitting in the CB.
Milords, the admissions are underway and I am a university who has to grant admission. Milords, if it is in September, the SLP might become infructuous because the admissions could be completed in August itself, Milords.
You don't have any date in August.
Thank you. Yes.
Please.
Please, your lordship. Lordship, this is a matter where the disabled girl. She was taken as per the advertisement. She was interviewed. She was selected. After selection, there was a medical examination, and in medical examination, she was determined to be less disabled than the criteria.
Okay, we'll have it on Monday.
Very well.
There's one similar matter today also. Is it from Patna?
No, your lordship. This is from Assam, your lordships. Oblige, your lordship.
But this is admission matter, my lord. Service is complete, my lord. Counseling will be over, my lord.
Listed on 16th of September.
My lord, kindly before that, the counseling will be over. SLP
ठीक है दूसरे बेंच के सामने लगा रहा है.
Yes, sir, lord.
Next week.
Next week?
They'll give the date, yes.
But this matter pertains to marks of a student and he'll be soon applying for postgraduate. No, it's been repeatedly deleted. No, some date may be fixed and not to be deleted on that day.
And how can we do this?
September.
On some Monday.
My lord.
Very well.
807, my lord, it's a case of life imprisonment. It was listed before your lordships. It's a review petition in court number 2 on 21st January 2025. Notices were issued and appearance have been made. Next Friday, my lord.
Not next Friday. There some date, some Monday.
Great.
My lords, this is a fresh application in the.
To be deleted.
My lords, it will be listed tomorrow then.
Yes.
Oblige me.
Not to be deleted.
Lordship, this is a service matter and there has action been passed by your lordship.
Not to be deleted.
Not grateful, lordship.
This matter pertains to the issue of salary of the Home Guard in the state of Punjab, my lord. This matter was lastly listed on 7th of April, my lord. My lord directed to list it after 3 weeks, my lord. Small issue. Won't take more than 5 minutes, my lord. Any Monday or Friday, my lord.
Okay.
Deeply obliged, my lord.
Your lordship, this matter pertains to land acquisition in 1962 and the compensation awarded in 1970. And the issue pending here is just about the quantum of compensation. However, we are from the respondents and I'm 60 years old. So I request it may be listed at any earliest date.
Already listed on 23rd September, not to be deleted.
My lords, unlisted mentioning, this pertains to MBBS admission NRI quota. The counselling is getting over tomorrow. The High Court directs giving admission to a student who has forged documents. So I'm praying for listing tomorrow, my lords.
Or is not possible.
My lords, day after.
Monday.
My lords, counseling.
We can't help now. We are with so many matters.
Understand, my lords.
Matters.
My lords, day after, if my lords, the counseling will get over. Otherwise, there are 600 students, NRI students waiting for admission. Otherwise, my lords.
Friday.
Obliged.
With my lord's permission.
Okay.
With my lord's permission, may I please mention SLP number 20566, my lords. The matter pertains to NEET undergraduate admission process, my lords. The petition.
Number?
SLP number 20566, my lords. Matter pertains to NEET undergraduate admission process for 2025 academic year, my lords. The petitioner is a domicile and a resident of state of Goa. Your lordship, I wish to notice on 30th of July, returnable within 1 week. I'm only requesting for not to be deleted from 12th of August, my lords.
With my lord's
Not
permission.
to be deleted.
My lords, I'm so sorry. I understand Friday is a holiday. My lords, Thursday in that.
With my lord's
That's what
permission is
mentioned.
There should be some order in which the yes, we start from there to this.
My lord, may I mention item SLP Civil 15526 of 2024. Lordship, the matter was supposed to be listed today. I had mentioned the matter, but the matter is not listed. The matter was lastly listed before Justice. It is about the property matter, Lordship. This matter is listed before the execution court on the 13th, Lordship. However, the adjournment letter has been rejected by the court. On the last occasion, the matter was adjourned before the execution court only because the matter was pending before the Supreme Court, Lordship. But matter has not been listed since 4 months. Lordship may kindly consider it and keep it tomorrow, Lordships.
How many matters we can take?
It was listed before Justice Bella Trivedi and Justice Vada. Tomorrow?
Yes.
Much obliged, Lordship.
May I mention that Zudpi Jungle judgment, Lordship, had passed on 22nd of May. We have filed a application for modification of a judgment. I am requesting Lordship.
Modification or clarification?
Lordship?
Modification or clarification?
Clarification, Lordship. Clarification, Lordship. I am requesting it will be kept on Thursday. A small application.
Not on Thursday, Friday. I think Thursday को तो पूरा दिन बैठना है.
Lordships issued notice in this matter in last 2024 November, returnable in 3 weeks, my lord, but it has not listed till date, my lord.
What is it about?
It's, my lord, regarding right to health to include the Ayush in the Ayushman Bharat scheme, my lord.
So we can. Yes.
Your Lordship, I could.
Let him actually. Are you also mentioning this one? You are also mentioning?
Yes, Lord. Your Lordship.
Let it be in the queue, yes.
My lords, if I may mention diary number 44549, this is a fresh SLP coming from Karnataka regarding the detention of a foreign national. He has already been granted bail by the High Court, but on the same day he has been picked up by the detention.
For SLPs on behalf of NHAI, Your Lordship, toll collection has been suspended by the Honorable Kerala High Court, which is costing me 50 lakhs per day, my lord. So,
on what ground?
On some statutory mandate not being followed by me. My lords, I request for the matters to be listed tomorrow, my lords.
Not tomorrow. Thursday.
My lords, I have also done the formal procedure of mentioning, my lords. My lords, because every day...
Thursday we are saying it.
My lords,
Yes.
I'm grateful.
Yes, please give way to the next council, madam.
Lordship, the Honorable Madras High Court had regularized the seats of Group D employees, my lord, against the unsanctioned post, my lord. In the contempt petition, which is coming up tomorrow, the Registrar of University has been called in person, my lord. It is contempt listed tomorrow, my lord.
So let him come. He has been called, let him come.
Lord, the seats has been regularized against the unsanctioned post, my lord. That's why seeking for listing tomorrow, my lord. My lord, it was even mentioned on Friday, my lord, for listing today, but it didn't come up, my lord.
He has been directed by which court to come?
My lord, this honorable court.
But let him come because there must be something why the court has passed the order of direction. Otherwise, normally we don't direct. I will know Friday. Thursday.
Thursday. Thank you.
But I am mentioning on.
Yes, Mr. Everett.
First, may I mention a matter? It's a matrimonial dispute. It's shown for 18th of 8th of this month. But the bench for which it was listed was Justice Bella Trivedi and Satish Sharma. I am requesting for listing on 18th on before and after.
Yes.
But I am mentioning for you on writ petition. needed to urgency test or Monday. The matter is the one of the in Gujarat, one of the Vanandara institute in the Gujarat. Vandar. They taken away entire temple elephant and forcibly taken away.
Lordship, mentioning a matter that was listed on Friday for clubbing of FIRs, Lordships have issued notice and tagged with the matter mentioned in the office report. I had also prayed for no coercive steps. The matter in the office report didn't have that or direction because he is still in jail, but co-accused has been granted that order of no coercive steps.
But what?
Already have it on Tuesday, so your Lordships has the paper book before your Lordships had.
Monday.
Monday, great.
Yes.
Lordships, Lordships, he is going to be released today. He has been granted bail only on 7th. Could your Lordships have it anytime this week? Otherwise, he'll get arrested again in the
Thursday.
Thursday, great.
My Lord's petitioner is an army personnel. He's been involved in an old 304B case. Notice was issued in the main SLP. We were asked to surrender. He has duly surrendered. He's a part of Operation Sindoor and a trained commando. We have filed an application for bail. My Lords, his family is suffering. My only request is that the matter may be taken up this week, my Lords.
That's it. Yes.
Please, with my Lord's permission, may I mention writ petition 783 of 24, my Lords? This matter had been wrongly tagged along with those Telangana medical admission matters. On that day also, I had sought for detagging. My Lords had ordered it, but it's not reflected in the order. I'm only seeking detagging, my Lords, because this matter pertains to Andhra and has nothing to do with those matters. Obliged, my Lords.
You don't want to be covered by that.
Please, my Lords, we don't want any complications. Obliged.
Yes. Item 1 is an application seeking modification of your Lordship's earlier order, my Lords. Lordships in 2022 are disposing of, my Lords.
What is the stage of the trial?
My Lords, this is the last order I have of the.
What is the stage of the trial?
Only one witness has been examined, but others have been.
Solve the state conflict.
I'll serve the stand.
Comfort and to bail, where the trial court had convicted me, the High Court had acquitted me in the first round by a well-reasoned order. The Lordships demanded the matter back, after which, the High Court has convicted me. Now, my Lords, in the impugned order, there is not a whisper of discussion about the submissions or the evidence of the defense. Now, please see page.
Here the appellates are on merit.
But some short date in minutes.
Yes. On some Monday or Friday.
Very well, Monday or Friday.
Friday, Monday.
Very good. Well, it's all on an NMD.
Well, I have been kind enough to
have read the papers
on Mondays and Fridays this second week to take up old well matters.
The trial records has to be sought for in this, Milords, because they are not on record.
Maybe what you have with the relevant evidence.
I'm sorry,
we have the relevant evidence.
We have the relevant evidence.
They have not annexed, Milords, any of
the trial court record will have to be called.
It has to be called, Milords. They have not annexed anything.
1990.
Call for RNP.
Milords, may I have it on in the month of October, September, Milords?
Call for RNP expedition.
Because translation, because it would be in Punjabi, so translation would also be required in that.
Yes.
99. Grateful.
Obliged, Milords.
Milords, he's going to complete 3 years in behind the bar and no charge sheet. Sorry, no witness has been examined and not even the summoning has been done. And there's no previous conviction.
There are no antecedents, but it is a commercial quantity for.
No, hardly 68. 50 is the.
69. So it is a commercial quantity. You are saying hardly.
Little bit above the 50.
Not little bit above. It is 19.81 grams.
Yes.
Above.
No.
You are saying little bit.
Commercial quantity for trafficking.
3 years. 3 years because he is behind the bar. No trial at all.
Yeah. Vehemently opposed by the learned case before the state on the ground that the petitioner has been caught red-handed with contraband. He is of a commercial quantity. Very good. Correct, the petitioner said that the trial is not progressing very. Only one witness has been,
No witness.
not a single witness has been examined so far. As we already observed in so many matters, that prolonged incarceration cannot be permitted to be sentenced without trial. That we have the matter we are inclined to allow the
Obliged.
Yes.
Yes, ma'am. But there is a liberty granted by this court to reapproach if the trial is not commenced within the period of 6 months by order dated 18th November 2024. But the petitioner has no antecedents, my lord. He is behind the bars since 3 years, 4 months. And my lord, for right from the period when the liberty is granted, my lord, for about 8 months, the matter was only kept for deposition of muddamal. About 14 dates. And with a gap of 20 to 30 days between each adjournment dates, which is again the procedural rule of adjournment also in custody matters. But there's no progress in trial. In fact, it's kept for deposition of muddamal on 15 days. And my lord, there's a minor son also who is dependent on him. 3.5 years, my lord, he's behind the bars.
minor son is staying with you or with the grandparents?
No, my lord. Right now he's in his family's custody.
With
His family's custody.
your family's custody?
Yes.
Yes.
Now, your lordships, at the very outset, I would like to submit that this trial is at the stage of evidence. Now, it will be relevant to look at the conduct of the accused and his advocate during the course of trial. Now, your lordships may kindly look at the deposition.
Lord, last 2 dates, I would like to point out, last 2 days, my lord,
And also, your lordships,
only on the last 2 days, his advocate was unwell, so he withdrew wakalatnama on the last date. And my lord, now they've engaged another advocate. But my lord, other 15, 16 dates, it's only
in the middle of the trial, they have
muddamal.
his advocate has withdrawn his wakalatnama.
Yes, my lord, because he was unwell.
They are only
But the
prolonging the
liberty
trial.
accrued-
Your lordships, they cannot be
The liberty
allowed to take
accrued-
advantage.
The other side also has. Let us complete.
Lord, the liberty accrued on the very day 18th November 2025, and my lord, on 20th May 2025, notice was issued by this court. But they have started the trial only after issuance of notice by this court and after filing of this SLP. Only on the last date, PW1 was being examined, and my lord, now they have engaged another lawyer for the trials. Only on that last date, my lord, there is the lawyer did not appear because he was unwell, and they've engaged another lawyer. Otherwise, my lord, on 15 days, the matter has been only kept for deposition of muddamal. And my lord, even as per the allegation, my lord, this is the case of.
No, but you go to the complainant's house, you stab the brother of the complainant. He is running, you follow him in the shop.
My lord, here, even at the most, the allegations that would be.
Yes,
He is a father.
Suppose even if you are, for some reason, convicted under part 1,
Yes.
not under 302, still there. For part 1, it will be 10 years.
10 years. My lord.
Part 1 is normally it will be 10 years.
But he has already undergone 3.5.
And half. So
During the
it doesn't come to even half of that.
But during the pendency of trial, my lord, no trial has also not progressed. And my lord, there was an order of this court. And my lord, there was an order of this court.
Not inclined to entertain.
Lord, within a period of 6 months, my lord had granted liberty, and my lord, there was no progress in trial in the last 6 months. So, my lord, page 103, if my lord will see, my lord.
If you want an order of expedition, permit us to dictate the order, otherwise we'll dismiss it outright.
Lord, because my lord had not expeditious, my lord.
We are not inclined to entertain the present application. How in the practice of the circuit, we are inclined to direct the learned trial judge to decide the trial, to conclude the trial expedition.
Lord,
As precious as possible, and in any case within a period of 1 year from today. Needless to say that, like, shall cooperate with the expedition disposal of the trial
Lord, my request for 6 months, my lord.
within a period of 2 years.
Lord, I apologize, my lord. I apologize.
Yes, or court masters know what this is.
Obliged. Lord, if my request for liberty to approach this court, my request for liberty to
Now the learned trial will conclude it within 1 year. Right?
If it doesn't conclude, my
Told you. The direction states. As requested.
Please, your lordship.
Here, my lord, the High Court has found
3 questions and responses to be suspect incorrect, we do not dispute that. The High Court expert committee of the High Court on the administrative side
Question number 8. What is the model key answer?
the question number 8, Milords, the model, all these answers were approved by the.
No. We are asking you what was the model answer?
The model answer said it is to be B, more than one boy were present from the class.
Wrong.
Yes, that is wrong. I don't dispute that. We are not here to dispute that, Milords.
I got
Was right in saying that A should have been the answer. I am not disputing that. But here what the High Court goes further is that it says for one question you do re-evaluation and then evolves a formula for marking, for making out the cutoff marks. Published or not.
8 weeks. Stay of the MP not.
Lords, I'm a 21-year-old medical assistant.
Directly to the Supreme Court.
Lord, there is an identical matter against the same parties which has already been to notice.
In the judgment which we have delivered, or was from the judgment of the High Court, authored by my learned brother.
Please, my lord. My lord, the decision of this one.
Why don't you go to the High Court? High Court is bound by our decision now.
Lords, I can go to the High Court. My lords, the difficulty is that there is already a writ petition which is pending before this honorable court against the same parties on the same issue. My batchmate.
We have decided the matter in the case of Vansh and Onkar.
Yes, my lords.
And that is arising out of the judgment of the High Court.
Please, my lords. My lords, there is a writ petition which for my batchmate has been filed before this
that can be a ground in the Supreme Court. That can be a ground to entertain a petition directly under 32.
Lords, I understand, my lords, but the grave difficulty is that the second round of counselling is happening.
Go tomorrow.
Lords, and 1 year has already passed.
Which is the High Court?
Lords, it's going to be Patna High Court.
Go before Patna High Court.
Lords, I can go to Patna, my lords, there is no difficulty, but the difficulty is that there is serious infringement of my fundamental rights.
We are aware about that, then we'll have to stop, close all the High Courts, put a lock on all the High Courts.
It is already pending before my lord.
It is not pending, it is concluded by us.
No, my lords, there is an issue which is.
There may be a writ petition pending, but the issue with regard to disability pension has been decided by a bench twice. Once me sitting with Justice Vishwanathan and once me sitting with Justice Sandeep Mehta.
Absolutely, my lords. I bow down. My lords, the only.
Therefore, those judgments are bound upon the High Court now.
Yes.
If that petition comes up before us, we'll relegate them to the High Court.
My lords, considering the same batch, same examination. I understand, my lords. I'm bow down. My only last humble submission would be that my batchmates' issue is pending before my lords.
We'll relegate them to the High Court. Which is that matter? Give us number of that matter. We'll thank you for. Let's give the number. Once there is a decision by this court, the High Courts are bound by that.
Certainly, my lords.
We'll list it into Lagan and Chaudhary. Tell them also. What do you want? Do you want to withdraw or should we?
My lords, I can withdraw and go to High Court if that liberty be granted, my lords.
Be granted.
Because in several cases, Dr. Satyendra has also been appointed by my lords in Anmol and other cases, and a complete assessment has been done, basis which the admission has been granted to various students with suffering from disability.
We have also entertained the petitions arising out of the High Court judgment. So, are the High Courts not entitled under Article 226?
Then I'll come back, my lords. My lords, may just give me that liberty, my lords.
This liberty to withdraw the petition with liberty to approach the jurisdictional High Court for the liberty granted. Since the matter pertains to the medical admission for physically disabled person, we request the High Court take up the matter expedition.
I'm so grateful.
If fine. If fine.
Please, my lords.
My lords had issued notice in a connected application under section 11, my lords. These are arising out of 3 EPC contracts.
Notice.
Maybe
Give the number of connected matters.
Item 11, the petition, section 11 petition was not maintained.
First was withdrawn without liberty.
Without liberty. And second,
one was
allowed, your lordship. I'm
Yes.
challenging the second, I'm challenging the second one was not maintainable for more than one reason.
returnable.
No.
Six.
Listen,
Stay of them around.
I'm praying for stay on the arbitration proceedings also because the arbitration has commenced. The arbitration is past section.
Take it once the legal order is stayed at.
I didn't hear that. I apologize. Apologize.
Some more reasonable time, my lord. I am paying rent, my lord. Regularly, I am paying rent, my lord. Only this source of income is with me, my lord.
Now we will issue a contempt notice to you.
No, my lord.
One year was more than enough. Normally in residential premises we grant only 3 weeks.
Lord, he was kindly gracious to grant me, my lord, 6 months time, my lord. That was there, my lord. 6 months already, your lordship has granted me, my lord.
Now you want till March 26.
No, my lord, some reasonable time, my lord. My lord, this is the only source of income with me, my lord. And the only shop, my lord.
What about the landlord?
No, my lord, he has to keep the it on rent, my lord. I am regularly paying the rent, my lord. I am not saying anything, my lord. I will, my lord, vacate, my lord, before the time your lordship granted me time, my lord. And I am ready to, my lord.
Issue notice, returnable 4 weeks.
My lord, since time is expiring.
You are hearing the other side, how can we pass an order? It is a dispose of matter.
My lord, then I will be in contempt, my lord.
Maybe.
My lord, your lordship may protect me, my lord. I am not saying anything, my lord.
Sorry.
For the next date, my lord.
Yeah, dismiss.
My lord, your lordship may just protect me, my lord. For the meanwhile, my lord, I am not saying anything, my lord. I am not saying anything.
Dismissed. How can we, without the issuance of their notice on an undertaking, a matter is disposed?
I have to vacate it by today, my lord.
You have given an undertaking, you have to abide by that.
Yes,
should have come.
but that's why I moved this up.
You should have come earlier.
I was moved, my lord, but it was showing, my lord, the before 8 showing, my lord, but now it is posted today, my lord.
You should have come at least 2 months earlier.
We filed on 22nd, my lord. We filed 22nd, my lord.
Only issue notice. Okay.
Please, highly obliged.
Because this is the matter
The High Court of Allahabad is not working.
Yes.
Whether the High Court of Allahabad is closed.
It's actually Lucknow that is the competent authority, but Milad, the only reason
Lucknow also has a bench, so whether the Lucknow bench has stopped.
The only reason that he is getting severe threats, even after filing the complaint before the DM and the CJM, the only reason was this. I am seeking liberty to withdraw the petition. I can withdraw the petition and go.
No, because I could, the letter confirming the petition,
Unlike-
they were to withdraw it. But the approach, the jurisdictional high court. By the court. Extended as requested.
Please, Malas. Malas, this is a case where there are two agreements, Malas. The mother agreement provides for appointment of arbitrator. The tribunal of three, where in terms of the provision that New Delhi is going to be the seat and venue, that's a mother agreement admitted position. And
It's in Delhi.
It's in Delhi.
Venue?
And whereas in the joint operation agreement, which was signed in 1995, is Kuala Lumpur, Malas. Now, the position is very clear that so far as the original agreement when it was signed, the production sharing contract, the terms were Kuala Lumpur, and that position was ad item in 90 because this agreement is, I hold 21% of participation interest in this. This went on till the extension was not there because this contract was for 25 years. In 2019, when the extension agreement came in, by that the time Union of India's policy came in, the extension is to be granted with certain terms, and one of the terms was the seat is going to be Delhi. That position was adopted and the amendment was made in the mother agreement, post 2019. So the position about the pre-2019 position is admitted that the clauses of Kuala Lumpur were retained. Post 2019, New Delhi was declared as a seat. That's the position is clear. So far as the joint development agreement is concerned, that was immediately signed post in 2005. There was the ad item, the provisions were there in 1995. That item provisions were there that the Kuala Lumpur will remain. Now, there was a clause in that agreement specifically saying in event of conflict, the production sharing contract will prevail. That position is very clear from the contract. Today, I am holding a 21% interest in that. The joint operation agreement was signed for very limited purpose that the oil fields which are to be operated, those oil fields are particular to be dealt with in a particular, and scope was given that if anything in relation to operation of the oil field will come between the four companies, that is the only aspect to be seen. This was not dehorse of the principal agreement, and rather I'll show from the clauses of the joint operation agreement, this was dependent on the principal agreement because the terms of the principal agreement was not deviated or modified. Let me show 2-3 things in this, Manoj. And the one more aspect, in the first agreement, Government of India was participating in the agreement, whereas the joint operation agreement, only 4 participating companies were there. This agreement, the production share agreement is page 81. If my lords can kindly come to page 81. And specifically, the parties are given at page 85. And if my lords may kindly note at 85, first is the President of India, second is the ONGC, third is Volco, which is Hardy today, fourth is IM, Hindustan, and fifth is the Tata Petrodyne. These were the 5 parties. Now, let's kindly see on page 86 and 87 that this was signed in wake of Oilfield Act of 1948, where the oil exploration as a policy was to be given to the operators. And if on 87 clause 7, my lords may kindly see, the government desired that the petroleum resources that may exist in the contract area be exploited and discovered with the utmost expedition in the overall interest of India in accordance with the good international petroleum practices. This was the basis. Then let's kindly see that one of the requirement here was that the page 117, article 6 is 116. 117 mandates that the companies sign the operation agreement. So the operation agreement was one of the aspects, but this was all subject to the principal agreement, which is at page 117. And one more aspect was the at.
No. Where is it provided that the production agreement will prevail over the other agreement?
Yes, I'll just straight come to that. The production the joint operation agreement is at page 353. I'll come straight to that.
368. Yeah. Well, the agreement starts from page 358. In volume 2 minutes. Kindly see 358 for a minute, brothers. And the relevant clause is at page 368.
It begins at 353.
Yes, the 58, 358 it begins at. And if my lords can kindly come to specific clause, which is at 368, article 1.43, my lords. .43, which is at page 368, my lords. 368, my lords. 368. Volume 2, my lords. Yes, fellas. 1.43, I'll read, fellas. In case of any conflict of any term of this agreement with that of the contract, and contract is, well, it's the defined term, and that contract is a principal contract, well, can take it. Then the provision of the contract shall prevail, which is the production sharing contract. One more aspect on next page, well, 369 is the scope of this agreement.
And in this agreement, the state is provided Kuala Lumpur.
In this agreement is provided Kuala Lumpur, whereas the contract agreement now post amendment, any transaction post 2019 is New Delhi, which is admitted position, which is not disputed. So the first is, in event of a conflict between this, the contract will prevail, which means the New Delhi is going to be the seat of arbitration. That's to see this 1.43. And everything is Indian law, asset is Indian asset, applicable law is Indian law. Now kindly see on page 369 for a minute, Malas, the scope and purpose of this agreement, because this is a very, very limited purpose. Clause 2.2 on page 369, Malas. The scope and purpose of the joint operations are limited to the prospecting, exploring and drilling of petroleum, the developing and operating of, and the producing of petroleum from the contract area. Contract area is defined, Malaj. Treating and field processing and the transporting of petroleum produced under this agreement to the delivery point, and appropriate supporting activities for any of the foregoings.
And what is the scope and purpose of the production agreement?
Yeah, production agreement is, well, it's the entire oil field, anywhere it is to be developed under the contract, because the contract area is defined. All terms inter se parties. The management committee is formed. Here only operational committee is formed. Management committee has the participation of the 3 government representatives in that, which can decide and determine the participating interest is to be changed in whatever proportion, depending on the circumstances arising out of production sharing contract. Today, the sole issue which is arising in this case, which has become a dispute, is that in a particular oil field where a new development plan has come up, if I have agreed or not agreed to participate in that by giving my respective percentage of expenditure on that, can you today say that your participation interest will vary and we will redistribute among ourselves without even looking at the production sharing contract? 1. 2. Second is that when the development plan has been approved by the management committee under the production sharing contract, which has been approved by them, which mandates that the production sharing, the development agreement should be brought in force within 90 days period, which has effectively not.
Yes, Mr. Rodke, what do you have to say about this?
The absence of the mother agreement, this cannot proceed.
With great respect, Lord, my friend is completely wrong. Now just give me 2 minutes. There are 2 agreements, Lord. One is the production sharing agreement, please note, it's called the PSC. The PSC, Lord, is between Government of India on the one hand, because Government of India is the sovereign owner of all oil fields in India. So in the PSC, Lord, you have Government of India on one hand, and Lord, the parties who will explore are on the other hand. So the contracting parties, Lord, are 4 on one side.
So one is the President of India.
Correct. And
one is the ONGC.
So
and the 3 others are the contracting parties, private parties.
All 4, including ONGC, are on one side. Government of India is on one side. Now, we are not concerned with the PSC. We are concerned with an agreement called JOA, Joint Operating Agreement, which is only between four of us, nothing to do with Government of India. Inter-sea, my lord, between the contract explorers is called the JOA. In the JOA, there is an arbitration clause. I invoke that clause. He has accepted that clause. He has argued everything without showing, my lord, that he has accepted. Now, turn to, my lord, volume 2 for a second.
Is it new in this court?
Sorry?
Is it new in this court?
Lord, just have a look now. Lord, with great respect, Lord, he should have shown that instead of going all over the place. Turn to volume 2 for a second. Volume 2, my lord.
Yes.
See now, my lord, only two documents. My lord, page 538 is my invocation.
Volume 3 hoga.
Volume 2, my lord.
Volume 2, my lord.
Volume 2. Annexure P4. Your Lordship will find this is dated 19th June. Does my Lord Chief Justice have it? Both the other Lordships. 19 June 2025. This is, my Lord, addressed by our lawyer to Mr. Balbir's client, Hindustan Oil Exploration, on behalf of the other three. Please note the subject, my Lord, notice invoking arbitration under 17.3 of the JOA. Please mark this and see the first para. We write on behalf of instructions of our clients Hardy, then ONGC, and then Invenair. Your Lordship, remember there were four parties on one side and Government of India on the other one. We are not concerned with Government of India. So all the three are writing, my Lord, to Mr. Balbir's client because, my Lord, he has walked out. So for whatever it is. So all three against him are total four. We invoke, my Lord, arbitration under 17.3. That, my Lord, your Lordship will find at page 547.
I'll request Mr. Rodriguez.
Paragraph 31.
I request it can read 541 also, just for continuation purposes.
If you don't mind. It's not important.
Para 13, 541.
Please turn to 547. In para 31, in view of the consenting parties, we hereby invoke clause 17 of the JOA to refer disputes and differences to arbitration as there is no other alternative, etc., etc. So 17.1, 2, and then 3. 17.3, my lord, unresolved disputes will go to 17.3. Now see 17.4. The arbitral tribunal will be of 3 arbitrators. Each party to the dispute shall appoint 1, and 2 arbitrators appointed shall appoint the third. Now, my lord, if the third can't be appointed, 17.5 is important. Any party may, after appointment of arbitrator, request the other party to appoint second. If such party fails to appoint an arbitrator on the receipt of so-and-so, second on the request of first party will be appointed by the Secretary General of the Permanent Court of Arbitration, PCA, at The Hague within so-and-so, so-and-so, so-and-so. Now, my lord, both of us, his answer is at 550. Mr. Balbir's client wrote back to us.
And the venue is the Kuala Lumpur.
Correct. Now to
17.12.
Yes. Now come to 551. This case is not concerned with venue or seat. It is only concerned with the appointment of third. Let's make it clear, bro. Our case today is not concerned with where it will be. It is only as to who will be the third arbitrator. Because parties have not been able to appoint the third person. Turn to 551. We acknowledge receipt of your reference of notice and accept, please mark, we accept the invocation of 17.3 of JOA. We are not concerned with anything else. While we agree dispute, let's see paragraph 3. They appoint Justice Bal Subramaniam in terms of 17.4, which I have shown to your lordship. Now, these two persons have not been able to appoint the third. So matter went to PCA, that is, my lord, Hague. And then there is, my lord, an additional documents filed by them. If your lordship will have that for 1 second, yes. Now turn, my lord, to. We are concerned with JOA. We are not concerned with the PSC. Turn to 149. So now, my lord, the Permanent Court of Arbitration at Hague is in receipt of this request.
Mr. Balbir Singh, where do you state in this reply that Article 17.3
yes,
of so and so is not applicable to the proceedings between two of you?
Yes, Manas, I must point out. Page 550.
No, your notice reply
yes.
begins at page 550.
Yes, Manas, yes.
You reply to their notice.
Yes, Manas.
And in pursuance to they're invoking arbitration
Yes, Malas.
to appoint ABC as an arbitrator.
Yes. Malas, kindly see, this was on 24/6 at page 550. Immediately, I responded because we admit that this was an error which was made. 564 at page 564. Kindly see 564. And 12/7/2025.
You can't jump from one.
No, it's not a question of jump. It's a question of which agreement to prevail.
You can't jump from one agreement to another agreement. The other agreement where nobody has invoked.
Kindly see page 56. I'm coming to specifically to this answer, my lord's question. 565 para 3, Malas. Rather 2 it starts from. By extension agreement of 7 September 2020, the production I'm sorry, 565 para 2, Malas. By an extension agreement dated 7 September 2020, the production sharing contract was renewed for 10 years on 29th December 2029 with all present parties executing the extension.
No, suppose if a production sharing, as per the production sharing agreement,
yes, ma'am.
If there is dispute between the Union of India on one hand,
yes, ma'am.
and any of you on the other hand, any 4 of you,
please, Malas.
Then that will prevail. But insofar as an agreement between all 4 of you,
yes,
subsequent agreement will prevail.
No, the dispute today is.
Are you having any dispute with the Union of India?
Well,
your dispute is with them that according to them you ought to have invested 20% or so and so.
Please,
and according to them you are not.
Yes.
And therefore they are entitled to damages. That must be only the claim.
So far as the joint operation agreement is concerned, it has no life of its own. It's coterminous with the existence of the production sharing contract. What the agreement joint operation.
Whether that 10 years period is over.
And this is their own case. So today what they say is that the management committee, which is formed under the production sharing contract, has approved my development plan, and I'm complying with the development plan. Now the development plan is not approved under the production sharing agreement of JOA. This is approved under the principal agreement. There is no approval of that. Once today any issue which arises, a comprehensive agreement of inter-se right between the parties is going to arise the principal agreement and not the JOA.
See the prayer.
JOA is only for limited purpose.
See the prayer of the petition.
Just time now.
You are
I'll show their own letter.
arbitrator.
I'll show their own letter. Can it be possible today to say that the inter-se right of operation is going to be determined de-horse the terms of the production sharing contract? Where I
page 46.
1 minute.
Yes.
Page 66 of their own letter I'm showing. Their own letter. Additional documents, page 66. Page 66, their own letter. I'm not saying this is how the issue started and they took a position. Page 66. This is 23rd February 2021. Because that's the dispute they are pointing out. Page 67, clause G. Hindu. May I read, please? 67, clause G. And this was the request for amicable direction. But I'm not on that. 67, clause G for a minute, Malas. HOEC, I am the petitioner, is severely in breach of the contractual provision, including but not limited to Article so and so of the production sharing contract and Article 2.2 and 15 of the JOA. So today to say that no, I'm not alleging a breach of the production sharing contract, that's not the position. Because in absence of a breach of the production sharing agreement, there cannot be way to determine or realign the participating interest. And this was that they filed a section 9 before the Madras High Court. In section 9, I'll show the order, which has been noted that it is in line with the production sharing contract. And it can't be in absence of the production sharing contract. That is only for the operational purposes. Page 556 is Madras High Court, Malas, which is in volume 2. And this is in their section 9. This starts from the page 556. And the direction which has been given specifically is at 562, clause C, Malas. Page 562, clause C. Kindly allow me to read this, 562, clause C. And this is after hearing the submissions.
Yes.
562, clause C, Malas. It is clarified that the interim direction issued by this court will not in any way prevent the first respondent from making claim against the applicant, second respondent and third respondent respectively before the tribunal regarding fruits of the purported exclusive operation of PY3 and to join operation in the field in terms of production sharing contract dated 30th of December 1994, but it's for the tribunal to decide whether the claim deserves. The entire claim arises of the production sharing contract.
Is there any production agreement?
Yes.
Determines any of your rights intersect between four of you?
Yes, yes, this will make the same order will make it clear. A7A on the previous page, 561 minutes. Without the inter-se rights cannot be determined. This can be only on the operation. The POA can only relate it to operation. A7A minutes on 561. The first respondent shall not interfere with the applicant, second respondent, third respondent in the oil exploration and further exploration conducted by them in the Kaveri Basin as per the production sharing contract dated 30th of December 1994 and also the commercial exploitation till the disposal. This is what they've argued and this is what the direction has been given. And now their own case made out the invocation letter, their own letter invocation, 541 for a minute. Their own invocation. I'm not go beyond that, what they say. This is the invocation letter I'm reading, 541. And this was raised to the government also. Para 13 and 14, two paras on 541. Pursuant thereto, the management committee, and there is no management committee, Malas, kindly note under POA, it's only on the production sharing contract with government participation. On 23rd March 2021, management committee decided that one RFDP, this is the renewed field development program, was approved by the MC, held on 15th October 2019. This is in dispute. Consenting parties are to take action by mutual agreement for implementation of the approved RFDP and WP and budget of 2021 amounting to so much must be implemented in financial year 21-22 as expeditiously as possible. 3, most important, necessary action under the production sharing contract are to be taken against the contracting party defaulting in the implementation of the WP&B, which is the budget of 2021. This is their own claim. There is nothing which arises out of the JOA. It's only production sharing contract. 4, consenting parties shall mutually decide among themselves the right and obligation of the non-consenting parties in terms of production sharing contract and JOA. During the said meeting, MOPNG also observed that HOEG, which is the petitioner, did not give any unconditional and firm commitment for funding activities for the commencement of production. However, petitioner before signing the said MC minutes against inserted postscript stated it is not in breach of production sharing contract and JON cannot be treated as a non-consenting parties in terms of RFD education.
One.
Right, so the last document, kindly permit only the last document. First volume, page 337. And this is the conscious effort between the parties because this document was signed by them also. And this is the extension document. They could have very well objected at that point in time. Page 337. This is because Government of India took this policy and the extension was granted primarily on this condition. I'll show policy also for a minute. Page 337 on volume 1, Malats. This will make absolutely clear, Malats, the intention of the parties right from the beginning. Today they can turn around and say anything, Malats. Page 337. Kindly note. I'm sorry, Malats. But this is extension contract for extension of the production sharing contract signed by all parties, and the date is 7th day of September 2020. And today the respondents are party. Malats can note this is given, the parties are given. Now,
there is no dispute.
And the entire explanation on this page. No, there is something turns on this. Mr. Yogi, just kindly allow me to just complete this. Page 343, specific clause. Specific clause. And this was a divided timeline. Prior to 2019, old clauses will apply, and post 2019, new clauses will apply. Page 343, Malats. Last para, Malats, just above that, clause 3.10. In Article 34.3 of the production sharing contract, following shall be added. That's an arbitration clause. Malats can take it for me, Malats. What has been added is the dispute, differences and claim arising out of or are referred to the sole expert, arbitration or conciliation before December 30, 2019 shall be governed by the provisions of Article 39.4 and to Article 34.13 of the production sharing contract. And those referred to sole expert, arbitration or conciliation on or after 2019 shall be governed by Article 34.4, Article 34.7, 34.8, 34.10, 13, 14, 14.8. Now the clauses start from 3.11. First time as a policy shift, and this is based on the Government of India's policy. 34.14 says, notwithstanding the provisions of Article 34.5, where an arbitration initiated on or after December 30, 2019, any party may, after appointing an arbitrator, request the other parties in writing to appoint the second arbitrator. If such other party fails to appoint an arbitrator within 30 days of receipt of the request to do so, the second arbitrator shall be appointed in accordance with the Arbitration Act 1996. This is for the second arbitrator not appointed. 34.15 is when the third arbitrator not appointed. Again, the Arbitration Act. 34.16 is the Arbitration Act and rules to apply to arbitration initiated on or after 30th December 2019. 34.16, notwithstanding the provisions of Article 34.9 and 34.12, for the purpose of arbitration initiated on or after 30th of December 2019, the arbitration agreement contained in this Article 34 shall be governed by the Arbitration Act of 1996. In amendment,
Specifically, the provisions of 1996 Act have been made applicable.
With great respect.
You are a signatory to this also.
We are talking.
It requires to be heard. It can't be heard on one day.
I'll file a reply, if necessary.
File a reply.
But I can only say, I invoke the JOA. Nobody has invoked the PSC. Neither he nor me. How can we talk about an agreement which nobody has invoked? I have invoked a particular agreement. He has accepted that invocation.
If according to him,
yes.
If there is a conflict between the two.
There is a question of conflict. This is one agreement between four of us. That's the other agreement.
Notice.
Do consider the prayer. The prayer is only
for
his side.
Third arbitrator. If you are agreeable for the bill to appoint a third arbitrator. That is the JOA.
They are not agreeable to go to the PSC. Yes. Who has invoked the PSC? Either he nor me. And now the Permanent Board of Arbitration at Hague has been moved because they are the third appointing authority. They are going to appoint somebody next week. Not sure we see that also. No, they can decide whether this court.
That choice is yours. Sorry. Suppose if we come to a conclusion,
no doubt
that there is a conflict and it's our jurisdiction to appoint an arbitrator and
I'm not saying no. If not,
but even if the
I am not saying no, my lord. If your lordships have jurisdiction, they have legality.
Even if the city is Kolkata, you can agree on a venue at Delhi.
This is the.
But no, I can agree. I don't mind agreeing here for the third arbitrator right now. I don't mind. But it can't be under the PSC. His prayer is to appoint a third arbitrator without in the PSC. If there is no first, there is no second. How can there be a third?
I'll file your replies.
In the meantime, the food ICT.
No, we cannot touch anything.
Yes, is that there's no.
If they appoint it at your own risk.
No, that's right. So I only record my sufficient because I don't want to, at second time, whenever the matter is heard, I'm pointing out that they have moved, they should hold their hand. That's all I'm requesting. They should not,
I should be hold
on this ground tomorrow, they should not say that your petition has become interruption. That's all I'm trying to protect.
I will say whatever I have to
Whatever,
say. I should not say this. I should
trying
not
to protect me, whatever way. I have no difficulty, I should not be thrown out on the ground saying that Mr. Rodriguez has already said that already been appointed. That's all I'm praying.
Was a petitioner. Praise for a direction to the respondent to not to move the international council of arbitration.
Permanent court of arbitration.
Arbitration at Hague for appointment of the third arbitrator in as much as according to the petitioner in view of the agreement between Union of India, ONGC, and you are wrong that India. You are saying that Union of India is on one part and the other, all four are others.
In the
it is other way. Union of India and ONGC are on one hand and all the three are on the other hand.
No, my lord, ONGC is here. ONGC is the protecting party. Only President of India there.
But this is Union of India policy. The extension was granted only on policy.
No, my lord, let's be very clear. It's only Union of India on one side and all four on this side.
On one hand, and the other three exploration companies on the other hand, it will be, this court will be entitled to appoint the third arbitrator. We are not inclined to grant any injunction at this stage, in as much as if the respondent desire to proceed further with their application for appointment of the third arbitrator before the Common International Tribunal. It will be at their own risk, and needless to state that shall be subject to the result of the further orders to be passed in the present proceedings.
Deeply applied.
ONGC is appearing here.
Yes, Lord.
On this side,
on this side.
Lord, I was the original licensee. Then these other parties, the other contracting parties were brought on board. We all became effectively contractors under the PSC. But this concept of exclusive operation only and only arises under JO. Please note one thing, my Lord. The other two arbitrators who are already appointed are admittedly appointed under the JOA. There is no appointment, but the prayer is appoint presiding officer under some other.
After 1 month.
No. After that, before that, what?
No, you agree to their request. And after around 25 days, you write second letter.
That's what has happened.
I'll show. Let the reply come. I think there is a one letter.
Otherwise, the section 11 can't take below half an hour. Section 11 has to take 2 minutes. There is an agreement to go to arbitration.
Within how much time will file your reply?
It will whenever your lordship says. We are all here whenever. I can do it in 10 days, 15 days. Your lordship may keep it in the first week of last week of August on a miscellaneous day. We do it.
No, but then now we'll be tied up with the presidential reference.
Your lordship may do it after the CV then.
Immediately after written level publish then the CV के बाद immediately.
Correct. We file it. That's the long and short of it. But after agreeing, somebody gave him a bright idea. Now let's examine the PSC. Story wrote that
law. That the which agreements, because nothing turns on the POA.
Can you tell an arbitrator you are appointed under JOA today and tomorrow you will be deemed to be an arbitrator under the PSC and you have a third chapter under the PSC?
How can laws have laid down the tribunal not constituted?
Trying to mix up both. I can't mix up.
I'll answer that one.
That's the long and short of it.
Grateful, Malaj.
Okay.
16, I'm checking the password. Head by council. Checking the password.
All that we are saying is, my lord, that this sewerage plant.
It's 204 meters away from the.
My lord, I see the map. My lord, for the premises.
That NIMBY phenomenon.
No, my lord.
No, not in my backward.
No, my lord, that's not the point. My lord, we are, the Gram Nala is next, very next to it. My lord, kindly see the map. If they are able to provide, my lord, 100 meters to 100, 200 meters of thick plant within their premises, they can't come on the road, my lords, to have this 100-meter, my lords, of plantations. My lords, may say this one, my lords. Kindly turn to the map, which we have filed, my lords. Well, addition documents, we have filed the latest map, my lords. Which was not there, my lords. But unfortunately, the real position on the ground was not brought before the court.
Go and file a review.
Well, with liberty to come back again, my kindly see the position of the map, my lords, page 9 and 10.
You are appearing in the matter.
Page 9 and 10, my lords. They are the maps. Kindly see how close they are. How will they have this 100 meters to 200 meters of thick plantation in this, my lords? Kindly turn to page 9 and 10. My lords, we can go back if my lords give the liberty to file a review and my lords come back again here, my lords.
No, STP side it's
My lords, kindly see that. My lords, kindly see it is so nearby, my lords, and they are going to have this plantation. These are all thickly populated.
STP site has been shifted 150 meters away from Ramnala and 20 meters from the court structure.
Correct, my lords, but my lords, kindly see this is.
Where will it go?
My lord, my lord, it is always on the river of Jojri. There is a river Jojri which flows in the district of Jodhpur, my lord. My lord, we have annexed, my lord, these points were not, we have annexed how the, at page, my lord, kindly see page 7 of the same document, we have said how on the river Jojri there are already sewerage plants. It cannot be in the midst of the densely populated area. That's all I
The petitioner seeks liberty to withdraw the petition. The process is withdrawn with liberty as paid for. In case the petition doesn't succeed in the review, will be at liberty to approach against challenging both the order hearing and the review order.
Obliged.
I appear for the third noticee, my lords. Mr. Nagamuthu also appears for some of them, my lords. I have filed my
report with this Patil, I am appearing.
I have filed my affidavit, my lords, unconditionally apologizing.
So, Lord, my affidavit is ready. I am appearing for Peddi Raju.
Second. You are appearing for R1.
No, R3, that is Nitin Meshram.
I'm appearing for that. My affidavit is ready, my lord. I'm unconditionally apologize, my lord.
R1, who is?
Yes, I'm appearing for.
R1 was the client.
Are you not
Who I am appearing?
expected to exercise a degree of restraint when you are drafting the pleading?
Absolutely, my lords. I unconditionally apologize. I've also put on record the circumstances in which it slipped my attention.
But there is not an unconditional apology. If you are trying to justify it.
No. My apology is unconditional, unreserved. I also apologize for my error. And in further mitigation, I only say that my brother was dying at that point of time. I went and I missed it. That's all. That's all as far as Mr. Meshram is concerned. During the vacation, my lords, sometimes these things, it's a mistake. It's a mistake, my lords.
You also filed an.
I filed please, my lords. If your lordship sees that.
You file an unconditional apology before the division bench of the. It was single judge or division bench.
That matter is over. Single judge court. Yeah. Transfer question petition allowed. That matter is disposed of, my lord.
Didn't dispose of matter, you can
file it.
You are making scurrilous allegations against
We will file it.
Judge of High Court.
Please,
You need to put it or.
My affidavit is there also.
We have no objection to filing that, but we are also officers of this court. We have apologized to this.
You apologize to the High Court?
Yes, my
It's on behalf of, may I submit notes?
Yes, you are appearing for whom? Nagmati.
I am appearing for the AOR, my lords.
R2. And R2 is the AOR, R3 is the council.
But we are not defending anybody, my lords. We understand the seriousness of the issue.
Fair enough. Proceedings came to be filed before this court, seeking a transfer of a petition from the High Court of Telangana to the High Court of Judicature at Bombay Nagpur bench of similar petition number 4162 of 2020.
Telangana to seeking the transfer for Nagpur.
That's what we have said.
Yes.
We said the same thing. And from Telangana, not to Bombay High Court, but a specific bench of Bombay High Court. The ground on which the proceedings were thought to be transferred was that the conduct of the learned judge was hearing the matter gave rise to serious apprehension of partiality and procedural discrimination in as much as arguments of the counsel or the petitioner were summarily curtailed. It was submitted that he was given only 5 minutes to argue the matter. And the further amendment made in the transfer petition was that given the political stature and executive control now wielded by the respondent number 1, the petitioner believed that there existed a likelihood of derailment of justice. We have dismissed the petition while our order dated so and so. However, while dismissing the petition, taking into consideration the scurrilous remarks made against the learned judge of the High Court, we had issued notice not only to the petitioner but to the AOR respondents who had filed the petition and respondents who had drafted the petition. 5. The Constitution bench of this court, in the case of, at least if you are seeking a transfer to Nagpur, you should have been aware about the judgment that was from the Nagpur High Court. Constitution bench of this court, in the case of Nagpur and others, reported in 1954 to SAC 544 has observed the applicable. 5. It can thus be seen that upon consideration of law, the Constitution bench clearly came to a finding that not only the party who files petition making scandalous allegations against the judges of the High Court, but also the lawyers who subscribe their autograph to such petitions are equally guilty of contempt. In response to, we are therefore issued notice to respondents. In response to the notice issued, all the 3 notices have filed their response by way of an affidavit.
Affidavit.
File it.
Yes. Yes.
We heard Shri. You are appealing for number 1?
Varun. Yes, Varun. I'm appealing.
For the number 1. 3. Nagmatu for number 2.
Around 2 minutes.
Nagmatu Senior Council for number 2. And the Egre, the learned Senior Council for number 3. Very good. you have noticed that nowadays it has become a trend amongst the lawyers, besides the judges of the High Court or the trial court, for no reason. Also, it has also become a trend that whenever a matter involves a political figure in a particular state, to allege that in that state, petitioner may not get justice and therefore seek a transfer of the proceedings from that state to any other state. Such practices cannot be permitted to continue. First of all, the judges of the High Court are also constitutional functionaries. They enjoy the same immunity as is enjoyed by the judges of the Supreme Court. First of all, paragraph. Under the constitutional scheme, the judges of the High Court are in no way inferior to the judges of the Supreme Court. First of all, though as an appellate court, the High Court to the Supreme Court can reverse, modify, affirm, reverse, modify the judgment of the High Court. Also, it has no administrative control over either the administration of the High Court or the judges of the High Court. Also, paragraph. As such, when scandalous allegations are made against the judges, it becomes the duty of this court to protect the judges of the High Court. Also, the perusal of the affidavit of apology would reveal that the apology is tendered only to this court. In our view, the contemptuous allegations are made against the judge of the High Court. Therefore, it would have been more appropriate for the petitioners to tender an apology to the learned judge of the High Court. Paragraph. We therefore permit the petitioner to tender. Because we therefore permit the respondent to permit the unconditional apology before the learned judge of the High Court. Paragraph. Since the criminal petition number 4162 of 2020 is already disposed of, we direct the Registrar General of the High Court to reopen the said matter and place the same before the learned judge who had passed the final order in the said petition. First, on reopening of the said proceeding before the learned judge, the petitioners, the same shall be done within a period of 1 week from today. Yes. On reopening of the said proceedings, the respondents shall tender an unconditional apology before the learned single judge within a period of 1 week of the reopening of the matter. First, the learned single judge would decide the question of acceptance of the apology within a period of 1 week thereafter. We will consider the issue with regard to acceptance of apology tendered to this court by the petitioners after the matter is disposed of by this court. Paragraph. Time and again, we have repeated that the courts have no pleasure in penalizing or sentencing the lawyers for acting in a manner which would amount to contempt of this court. Recently, the 3 judges bench of this court, which 2 of us, Vijay and Justice Chandran, were a party, deciding a reference with regard to the difference of opinion between 2 learned judges of this court with regard to sentence imposed on 2 lawyers of this court, had observed that the magnanimity of justice lies in not punishing someone, but in forgiving someone for the mistakes committed by the lawyers. So we are therefore agreed with the view taken by the learned judge, who had accepted the apology tendered by the lawyers. Paragraph. While we decide the matter, the next day will be guided by observations made by this too.
Very grateful. One more line, but only name is.
Opening only for the purpose of opening only for the purpose of accepting the apology.
We are very grateful, madam. One more small submission subject to my lords appreciating. The lords may accept our unconditional apology.
We are saying that we will consider after 4 weeks. We are not closing the matter. We have observed in the subsequent paragraph as to what is likely to be done by us.
We feel really very sad, my lords, what is happening.
Your Lordship, it is may permit us to file an affidavit of apology before the High Court. My lords, yes.
So that is what we have said. Now the matter is closed.
Yes.
We have directed the Registrar General of the High Court to reopen the matter only for the limited aspect of accepting the apology.
Yes, my lords.
For filing the apology.
Yes, only filing, because sometimes the High Court may say that personal appearance, etc., etc.
No.
So that
needless to say that the parties will be at liberty to file affidavit apology through email and so on. If necessary, the learned judge may consider permitting the parties to appear to video conference.
obligements. Very grateful. I was noticing that in 1954 there was a High Court of Nagpur. Maybe Maharashtra.
In 1960 there was a High Court of Nagpur.
Then the reorganization.
Then the reorganization. So the Jabalpur, the MP High Court is successor of Nagpur bench.
Yes, please,
Nagpur High Court.
Yes, Central India.
Earlier CPI and Berar, then Madhya Bharat. Then on reorganization, that area went to MP, Madhya Pradesh.
Please,
my friend is very big in
read my own possible.
Hidayatullah. Justice Hidayatullah.
Get the entire story.
Please.
So how he shifted everything from first he took oaths at Bhopal, then the entire night he traveled by road to Jabalpur because he had to administer the oath to the other judges the very next day. Otherwise, he would have been the only judge, and there would have been a gap of some days between the judges. Because it was only the Nagpur judges who were transferred to the MP High Court, and then shifting of the entire library and all that.
One anecdote about Honorable Justice Vivian Bose, but I may take half a minute only.
Yes.
Only half a minute. But the bench was hearing a case under PC Act receipt. The defense was that money was thrusted into the pocket of the accused. That was the defense. The junior judge was asking, how is it possible to thrust the money? So bench went for lunch. When they again reassembled, Honorable Justice Vivian Bose asked the other judge, you see your pocket. In the pocket there was a 10 rupee note. He said, this is thrusting.
No, Justice Vivian Bose was actually a professional magician as well.
Yes. He wore many hats. He was an active member of Scouts. Then he used to cycle around all the way from Nagpur to Pachmadi.
Yes.
Then he used to drive from Delhi to London.
He gave us that famous quote that the law is for the butcher, the baker, and the.
Both Vivian Bose and Justice Hidayatullah and their wives, their spouses, all four of them traveled together from Delhi to London.
Birsa Singh holds the field even after so many number of decades. Birsa Singh case.
Birsa Singh.
Till today it holds the field. How many years?
Just in vacation, you read that. It's a very interesting reading. And there is a one special chapter on Justice Bobde's grandfather, M.R. Bobde. He describes him as the best judge that he has. He says that Nagpur had many eminent and very good lawyers. The best among them was M.R. Bobde. But why did they choose only Nagpur bench of the Bombay High Court?
That's no.
Mr. Mishram practices throughout the country. His jurisdiction is not restricted only to Nagpur.
He made a mistake. It is not the quantity of time that a judge pays or shows he is paying attention. It's the quality of attention that matters. That's all. I'm grateful.
Please, Your Lordship, High Court, though relegated the matter to the trial court, has virtually clipped the wings of the trial court now.
Though we are not inclined to entertain the present petition, in as much as the High Court has remanded the matter to the learned single judge, to the learned trial judge for considering the application of which under 319, we direct the learned trial judge not to be influenced by any of the observations made by the learned single judge in the impugn order, and we further direct that the learned trial judge to decide the application under 319 on its own merit without taking into consideration the observations made by the High Court.
So the only thing is, the fourth direction, till the exercise above is over, the aforenamed witnesses shall not be examined by the prosecutor.
You will learn trial judge will decide it with expedition.
Otherwise, no difficulty about that. Only thing is that the trial court will not be permitted to examine the witnesses. The three witnesses are parted witnesses. And
we direct the learned trial judge to decide the application on remand in a period of 2 weeks.
Lords, trial may be allowed to proceed with regard to other witnesses. So, trial should not come to a standstill.
Needless to say that, except there are only 2 witnesses who are concerned.
There are 3 witnesses.
Except the witnesses about whom the 319 proceedings are pending. The learned trial judge would proceed with the trial insofar as other witnesses are concerned.
Grateful.
I pray to my lords to permit the petitioner, Mr. Ghanshyam Upadhyay, to address the honorable court. He is himself a seasoned advocate. Lords.
How much cost, Mr. Upadhyay?
Cost, my lord?
Yes. Is the Bombay High Court, उसमें वो जो अभी जजमेंट किया था मैडम को, उसमें 1-2 पैराग्राफ ऐड करने को
तो ठीक है
Yes.
Is the Bombay High Court closed?
Lord, not, my Lord, that is not the issue, my Lord. My Lord, kindly help me to see the.
Why should we disbelieve our High Court judges?
Lord, I am not that aspect, my Lord. My Lord, kindly, my Lord, see the relief which I am seeking for this honorable court. It cannot be granted by the High Court, my Lord. See the, my Lord.
It can't be granted by the High Court.
Yes, my Lord, kindly, my Lord, see prayer clause C, my Lord. I am seeking very larger issue, my Lord. Prayer clause C of the petition, my Lord. Not only just registration of the FIR, my Lord. But this can be granted only by this honorable court under Article 142, my Lord.
Direct the Election Commission of Indian Election Commission of all the states in the country to formulate a scheme policy in coordination with each others to have watch and control on such illegal activities of political outputs, political parties of the country, which endanger or tend to endanger sovereignty, integrity, and unity of India, and withdraw. Why can't the High Court grant it under Article 226?
Lord, High Court, my Lord, can have, my Lord, jurisdiction only with regard to, my Lord, Election Commission for the state of Maharashtra, but not for all other states.
The High Courts will have jurisdiction wherever a part of cause of action arises in that court.
Lord, but my Lord, it will be not beyond the, my Lord, jurisdiction of the High Court, perhaps, my Lord, direct all the other state commission, my Lord.
The present petition is nothing else but a publicity interest litigation. Paragraph.
Lord, my something, Lord, just my Lord, my name is my Lord, just my Lord.
You have already been once in Bombay. We want some such observations to be repeated.
Lord, just my Lord, I am Lord.
Just for the sake of publicity, don't go on filing such petitions.
Lord, your Lord, may not say so, my Lord, see the gravity of the matter, my Lord.
We are aware about that.
Your Lord, may not, my Lord, grant me for publicity, my Lord, I have not done.
Can such a grievance not be raised before the High Court?
Lord, kindly see the relief which I am seeking. Under that impression, Lord, I came for this court. Lord, kindly, Lord, this one. Yes, Lord, may hear me, Lord, sometime, Lord. Lord, give me some hearing, my Lord.
The present public interest.
Lord, just give me some hearing, my Lord. Some indulgence, my Lord. Some indulgence, my Lord. Some
nothing else but attempt, but a publicity interest litigation.
My Lord, just permit, Lord, to some, my Lord, indulgence, my Lord. Some indulgence, some indulgence.
So we have time and again observed that for protecting the rights of the citizens, the public interest litigation is necessary. At the same time, we have frowned upon the judicial adventurism and judicial terrorism. The present petition, apart from being concerning the policy of the Union or the Election Commission of India, also does not show as to why the petitioner has directly approached this court under Article 32 without availing of an alternate efficacious remedy under Article 226. Paragraph. We are therefore not inclined to entertain the petition. Petition is dismissed.
Not only one, not branding, Lord, for publicity, Lord.
We will do whatever we want to.
Your Lord, just Lord, your Lord, my humble request, I have done Lord, I have come this with one of my intention, Lord. Your Lord, may consider that.
You have been already served once of the contempt. We will want me to again issue one notice one.
So Lord, may do one.
I have saved you once in contempt matter after holding you guilty of contempt.
Your Lord, may only one request, humble request, Lord. Your Lord, may not permit me to withdraw this petition, Lord. Will liberty to go to the High Court at least, Lord. That may be that.
Are allowed to withdraw with liberty to take such steps as are permissible in law.
Lord, High Court, Lord.
As are permissible in law.
Lord, High Court, Lord, may be directed, Lord, to expedite the matter, Lord, at least, Lord. It takes.
We are just not saying that we are not superior to High Court. We don't need to issue any directions to the High Court. You must have heard that. Don't make these gestures.
Pardon, Lord?
Don't make these gestures again.
Thanks, I leave it to this court, I said, Lord, I did not.
Don't make these gestures and don't show faces to us. Otherwise, you will be inviting. I am the last person to send anybody under contempt. But don't remind me of Bombay days.
Lord, just I request, I
You
said.
You have a retrospection and recollect what saved you that time. Don't make me remind you of everything that happened there, and don't make me say those things in the open court. Once you have withdrawn, better try to catch the next flight to Bombay and file it tomorrow.
I'll do that, Lord. I'll do that.
One of this is basically a civil dispute. My lords, for the same offence, 3 FIRs has been lost against the petitioners, my lords. Stay the proceedings, my lord. Stay the proceedings, my lords, before the trial.
Will you permit us to?
Oh, sorry, I'm so sorry.
Get the order first.
Sorry, my lord, I'm so sorry.
Issue notice, written about 4 weeks. Stay of the proceedings before the trial court.
In this case, my lord had appointed me as a amicus. My lord, the question is, my lord, with respect to the High Court, my lord, the High Court has misinterpreted the judgment of this court. All the public documents, including the PAN card, Aadhaar card, are in his new name. It's a correct, he's changed his name, there's no doubt. And the single there are 2 writ petitions were decided. The other one has been implemented. His correction, he also changed his name. I don't know what problem they had when the PAN card, Aadhaar card, everything is in. Then the division bench says you still go and get a declaration from the civil court. That's not what this court had.
Issue notice because they are not there. Notice is not there.
Not been issued, my lords.
Issue notice, written about 4 weeks. Justice permitted. Liberty to serve the standing counsel.
All right, December. My lord's only request is because he has to apply for CLAT, and that December is the date. So if my lords can have it in October somewhere.
We are saying 4 weeks. I would on some Monday only. Thank you very much for rendering your services.
No. 36 minutes.
वो दूसरा जो मैटर उसके साथ रख दीजिए वन शक्ति का दूसरा मैटर था ना नोटिस टैग कर दीजिए
36 minutes.
This is not one shakti.
Sorry, 36.
Minutes, 36 minutes. I filed an extension of bail. I have granted. And 25 minutes, I was granted 3 weeks. The petitioner's wife is suffering from blood cancer. Almost on the last, very critical situation. She is under.
Yes.
Your Lordships, we seek a short passover. DSG
What passover now? What is okay? Anyway, who is happening?
ASG. Learned ASG ST Sanjay. He's on his legs in 17. Learned ASG ST Sanjay.
Sanjay, okay.
May please your lordship. 30. Yes. Please your lordship. What happened in this that the honorary single judge has interpreted a new way of Article 235 and 236, saying that the High Court's exercising of Pardon, my lord?
Were you graduates?
My lord, I was a graduate.
Then did you inform about your graduation to the?
No, my lord, what happened in this matter is that I must concede that I did not disclose this fact when the early advertisement was issued, but I was being appointed. The notification which the learned single judge relied upon, saying that as far as the High Court's notification under Article 229, I am not eligible. But the 229 is restricted only to the establishment of the High Court offices, not to the subordinate judiciary. As per as this honorable court's order, judgment in Renu's matter, the High Courts were supposed to bring a centralized system as far as the recruitment of grade 3, grade 4 in the subordinate judiciary is concerned. In the state of Assam, that rule is pending since 2018. Now what happened is that when I raised this matter in my review, the honorable single judge said, no, High Court is right because High Court has exercised this power under 235 and 236, which is against the law laid down by this court itself.
You are not qualified.
Well,
We are overqualified.
the question is that
Your qualification should be only such and such.
qualification is only 8 passed minimum. But as far as the High Court's regulation, High Court's rule 220 under 229, with the subordinate, with the High Court's own staff, it was not to be more than class 12. I was graduate. My question is that the notification which.
But what did the advertisement show the advertisement?
My lord.
The advertisement.
Pardon? Page X.
181.
181. Annexure P6, my lord. I am with respect to serial number 4. Minimum 8 standard pass.
What is it?
182, my lord.
Where does it say that the qualifications having higher qualification than such and such would not be entitled?
That came up after a corrigendum was issued.
Where is that corrigendum?
Is it? My lord, may kindly come to page 13.
1-3.
1-3, my lord. This is where it has been reflected, my lord. Mr. Advocate Learned Counsel, appearing on behalf of the review applicant, submitted that an error apparent on the face of the records had crept it on the ground that the notification dated 28/1/16 was in reference to the power.
Why don't it show us that corrigendum to the advertisement?
My lord, your lordship will kindly come. That notification is of 28th January 2016, page 37, annexure P1.
Whether the advertisement corrigendum was issued, that if a person is having such and such qualification or above such and such qualification, he would not be entitled to.
That was in the writ petition at the time. That notification was there, and that has been reflected in the order.
That is not reflected in the advertisement. Was there a corrigendum advertisement issued is what Milord.
My lord, I must say it was issued.
Where is the corrigendum advertisement?
At this point, I'm not having it. Yeah. My lord, kindly come to page 70, my lord. 174. I'm so sorry, my lord.
That's a notification of the High Court.
All those have filed as above shall be in
Yes, page 74.
Page 174.
174.
174.
Where is the corrigendum issued to the advertisement?
My lord, I'm not annexed it.
Do you get that?
My lord.
Take time to place on record the corrigendum issued to the advertisement inviting applications for recruitment.
Can it be posted on a specific day, my lord? Because I have already been thrown out from the services.
2 weeks beyond.
My lord, delay is there. An application for delay is there.
So, control.
Obliged, your lordship. Obliged.
Item 39 is a fresh.
Try to go along with the
notice, yes.
Notice
Different issue, but clarification go along with that. It's a different issue. Some actual date may be given because we have actually got deemed sanction. They will never accept it without a lordship's order.
Monday को लगा दीजिए.
Source my lord.
I have done some Monday.
Yes, very obliged.
So Argani, we had removed that cost.
I'm sorry.
We had removed that cost part.
I'm obliged, grateful to
You have to be obliged to my learned brother, Justice Dadran and Justice Ajarya.
I'm so very grateful to my lord.
I was sitting in court. Your lordship should not take it back. I was sitting in court that day. The second offer that day was a separate disjunctive offer by my learned friend to give that amount to the legal aid society.
That he will give otherwise. He is very generous.
That should be made a rule of the court. And with a percentage.
Lordship, in item 40, I'm seeking a sought accommodation. I'm led by Mr. Siddharth Dharmadika, reason a personal difficulty, Your Lordships. We have this matter anytime this week.
I know.
Okay.
Grateful, Lordships.
My lord, I couldn't hear the order passing.
He said that Mr. Dharmadikar is indisposed, therefore he wants time.
Lord, he has already appeared before the arbitrator. I don't know.
Also, his personal difficulty, we accommodate everyone.
Lordship is having it on
After 2 weeks.
2 weeks. Please, Lordship.
Plot 41, there was a...
No, wrote in your petition that clause 5 is already there.
Yeah, yes.
That was not pointed out the other day. So we are specifically asking.
Yeah, yes.
Where is clause 5?
But there was a confusion at our end. Yes, yes.
Yes.
That first.
Yes.
No, there was a confusion at our end, my lord, which we could not clarify. My lord, I have had a detailed discussion and this would make things very clear on clause 5, my lord, which is the fundamental basis of the High Court's judgment. My lord, kindly have a look at, my lord, this affidavit. My lord, clause 5 I have quoted for your lordship's ready reference at page 2. My lord, first of all, well, let me clarify before your lordship reads this. My lord, these are general terms and conditions on the government e-platform to be adopted by suitably modifying by all government departments and all PSUs. These are kind of a generic, my lord.
Yes, but then did you specify that this clause 5 would not be applicable to your contract?
I'll my lord, kindly help that. My lord, be with me for 5 minutes.
Yes, we are not in a hurry.
Yes, yes.
We are not in a hurry to dismiss the petition.
No, no, my lord, your lordship. Clause 5 does apply. It's not our case that it will not apply.
Therefore, let us read clause 5.
Kindly, my lord, do that. Kindly do that. Contracts. Following documents shall be construed to be a part of the contract generated through GEM. My lord, that is government e-market.
Government e-marketing, yes.
Marketplace. Scope of supply including price as enumerated in the contract document. No dispute. General terms and conditions would apply. My lord, no dispute. Now please see product service specific.
Would not apply.
There is no STC. That is where the mistake has occurred. I'll substantiate that.
No, on the contrary, your argument was that in STC, that clause is struck off.
SLA. That's where, my lord, the mistake has occurred.
There is no STC document in the current tender.
In the current tender.
That it is non-existent.
Yeah, yes.
Template.
Okay, SLA is there.
Yes. My lord, then for product track domain specific STC for particular services, that is service level agreement. This is there, my lord. Product says because every PSU will have a different product and therefore different. Correct, my lord. The scoring out part is in this document. There are 2 documents, my lord. Then, my lord, bid RA specific additional terms and conditions. This is also there. Kindly, my lord.
That is ATC.
ATC. So ATC is there and SLA is there. Now please see, my lord. And my lord, the terms and conditions stipulated in STC and SLA will supersede those in GTC. My lord, here there is no STC, so SLA will supersede. Correct, my lord? And the terms and conditions stipulated in ATC, my lord, which we have, will supersede those in GTC and GTC and STC. So GTC will be superseded. STC was not there. ATC I will show to your lordships. Now your lordships may kindly come to
supersession of SLA.
Yes, no, there is no supersession of SLA. That's the
condition. But then it could also be interpreted in a manner that the ATC will supersede.
But there is no STC. ATC also, kindly, my lord, come to page 62. Now of the paper book, and thereafter I'll my lord simultaneously read. Please, on the contrary, let me complete this and simultaneously take your lordships to the paginations. I state that in the present contract.
Mr. Dr. Singhvi, you are the petitioner.
High Court.
The High Court. Are you willing to give an undertaking that in pursuance to the bid submitted by bids which will be invited in accordance with the order of the High Court, you will match his offer?
Fairness, we should give that. I'll just give him a minute.
1 minute.
Ma'am, sir, there is one more difficulty. For the purpose of defeating the present contract, they might say yes.
No, my
Mr.
God,
Only a minute. Only a minute.
If you are Mr. Solicitor, you are only concerned about the public interest. You are saying that 1 minute. Let us complete the query.
My apology.
You are saying that you are getting 500 crores more. If that is only your concern, maybe now if that condition is known to everyone that they are not going to insist on the condition of the deposit of 269 crores, there might be many more bidders instead of
only one addition. Only one.
We are asking the learned solicitor. No, we are asking the learned solicitor. Let him respond to it.
You say something which he doesn't know.
We will call upon you after we receive his answer.
Very likely.
Only one. I bow down to your lordship.
If there is a confusion whether that 269 crores additional deposit has to be,
which I will be able to clarify, but taking from your lordship's last.
In the meantime, you ask your clients.
No, I will ask, but I need to argue for 5 minutes. I have not argued. Let him finish. I'll take only 5 minutes, your lordship.
No, then I will also argue, but let me answer your lordship.
I will take instruction, no problem.
Sometimes, this is a contract of 10,000 crores. This is a contract for excavation of coal, moving heavy earth vehicles, transportation of coal from the mines to the railway siding, etc. It's a huge thing. For the purpose of succeeding in the petition, he might say that, all right, I'll for whatever amount, Mr.
Was it technically qualified or not?
Technically is qualified.
It's only
Give me a minute more. Whatever Mr. Rothgi has quoted would be an upset price. Your lordships are saying that he will have to quote something.
No, we will consider upholding the order of the High Court only if somebody is there, that he will match his offer. So the public interest would be that there would be an offer lesser than that also.
Or there are other tenderers. We can go for reverse bidding also. We might get, somebody may give more than them. Somebody may give me more benefit than Dr. Singhvi's plan. I am not on that. But sometimes our experience is, and I have taken specific instructions from Chairman of Coal India. What happens is, with a view to frustrate the tender, what they do is, Mr. Rothgi says, I'll give 18.9% something.
The question is,
only a minute,
the only question is whether everybody knew that the requirement of additional 269 crores or
337.
I'll show that.
337.
337 crores would be waived even if somebody quotes above 50% bill.
I will show that, my lord, and I will bow down to what your lordship's suggestion after showing this. Let me show.
Because in Maharashtra, in Bombay, we have been in a position to save 3,000 crore rupees.
Correct, my lord. And we have no
difficulty. You can hold negotiation with everyone.
That's what I'm
saying.
I have no difficulty.
Instead of quashing the entire process, we can permit you to negotiate with all those who are technically qualified.
Correct, man. I bow down.
And that is permissible in accordance with the law laid down by this.
There would be one condition then they will have to file an undertaking that they will fulfill the contract. What happens, my chairman?
So if you find them technically qualified, you waive that 263, 100 so and so for them.
I'm saying something.
I argued quite a lot.
Kindly allow me.
Let him have the satisfaction.
He knows what I'm going to ask.
We know that you are in a hurry to go somewhere else.
No, I want to
always We have been granted you permanent liberty to go as and when you want to go and come back as and when you want to come.
Reason, madam, I are on 2 different dates. So I'm saying was today allows, Lordship not heard us. After you finish, there's something very interesting to be told.
Yes, sir, let him answer.
Very good.
We have still a lot of time to rise for lunch.
Manoj, I bow down. 18.90 will be can be the base price,
yes,
which is offered by him.
And then rather than watching everything, we can hold negotiations with all those who are technically qualified.
That's called reverse bidding, Manoj, with all technically qualified people. But what is our apprehension, I candidly share with your lordships. I had a Manoj discussion with
that apprehension is totally ill-founded in as much as we are saying that only technically qualified persons.
I'm saying something, Manoj, slightly different. Manoj, if your lordship, what happens is, Manoj, somebody says that, all right, I'll give 30%, hypothetically. It's an illusory figure. He also knows that he can't perform the.
So therefore, your additional condition of that 363, if somebody quotes below 15, quotes more than 15% below, then to secure that he doesn't run away, that additional security deposit of 3.
I'm agreeable. I'm agreeable. If anybody goes below 18.90,
yes,
they will have to pay. No.
There is a security of 350 crores today.
No, let everybody participate, no?
I have no difficulty.
Save my case. I was not obliged to give. Is my case. But will not push comes to shove. I will give it.
Now.
My lord.
Now, can I?
So, I have got improvements already. I have spent voting cases. We're starting the project of 10,000. It's not as just that we haven't started. Please go to the head governments of problems of equities.
No. Your favoritism.
It's not that he went to 14.9 and stopped. He stopped at 12. He was not interested in that. It's not even matching. Therefore, even see that one today will be below an extra advantage. I can understand a man stops at 14.9. So I can't go below because there is
we are saying that we will permit him to do so only if he is an undertaking that he will give an offer equivalent to you or below that.
I hear that. I will seek instructions.
And additional security.
And additional security to all.
Yes.
Now, can I?
All. Yes.
Why did he know? Why did he stop at 12.5%?
Because his condition is that he was not knowing that if he has to bid below 15%.
And he would have 14.8.
It's all favoritism. Malazar is favoritism. Allow me.
15 is the bench. So from the bench, you will be somewhere near the bench. You can't be at 12. And then there is an advantage that there is some confusion. And because sanctify the position, I have expended money. I have changed my
money is expended. Nothing at all.
When was the contract awarded?
July.
How is it expended? July.
2nd July.
He's throwing money to.
When was the contract awarded?
2nd July.
1 minute, Mr. Mehta.
2nd July.
You have to reserve your energies for the second half.
I don't think, my lord, he will be required to argue. I have argued on his behalf, but
25 site was handed over to me on 2nd July.
And where was the petition filed? When was the petition filed in the High Court?
1st July.
So prior to that.
Expressing an apprehension. Correct.
One day. So it is given to me on 2nd. I have to start it.
So then you have taken the risk when the matter is pending before the High Court.
I have to start
We'll hear it at length.
Now, can I?
That's how it was just.
We'll hear it at length.
My difficulty would be this. Lord, they have quote, and I'm agreeing to your lordship's, Lord, it's a very fair suggestion. That 18.9 would be the base price.
We feel that everybody must have a level playing field. And if there is any confusion that whether that 360 additional securities was liable to be paid or not, then that confusion has to be clear.
Lord, I bow down to your lordships.
Okay, let him show it.
That there was no confusion.
You have no objection for that.
I have no objection.
And as a public body, you should also not have it.
I must not make myself clear so that there is no confusion. As
now, let Mr.
Only a minute, as suggested by your lordships, 18.89, which was Mr. Rodgi's price, would be the upset price or the minimum price, so that now nobody can go above that. we will go for the reverse bidding with all technically qualified.
Only technically qualified.
Only technically qualified bidders. And whoever is selected will have to give additional security deposit.
How much you tell us about?
As per contract. As per the contract.
Then, according to as per the contract, there is nothing.
No, as per the
As per the ATC.
it's 4.6.
As per ATC. We'll say as per ATC.
As per page 104.
As per ATC.
Page 104. That's part of ATC. Yes, your lordship, sir.
Yes. Sorry, yes.
Can I have 5 minutes? Or 3 minutes?
No, 5 minutes.
All right, 5 minutes.
3 minutes is the doctor's finish.
Now, I want to show you, Milord, that there is no confusion and that the SLA, which scored it out, is, Milord, what would remain. Scoring out remains and there is no confusion is my case. I bid, therefore, Milord, 18.odd%. He bid, Milord, about 13%. The difference in his bid and my bid is, Milord, 1% is 100 crores out of 10,000 crores. So our difference is more than 200 odd crores. That's
500 crores.
500.
That's what Mr.
500 crores is the difference, Milord, in the bid. Question is, Milord, would the Supreme Court give an opportunity to a man who was 500 below me, who was nowhere near the benchmark of 15? I can understand the case. I was genuinely saying, well, I didn't know. There was a pre-bid conference. He could have asked. He asked other questions in the pre-bid conference. He didn't ask this question. What does it mean, Milord? You know what it means. Otherwise, the first question would have been, are you to give this security or no? Security is 350 crores. So please note, Milord, no.
He went before the court on a ground that though this condition was necessary, he came to know after a contract was awarded to you that the contract is awarded to you without.
That is wrong.
That's what the High Court has found.
Now, Milord, if that is correct and there was a genuine doubt, he would have asked this question at the pre-bid conference. That 350 crores is a lot. Are we to give? Are we not to give? If you go below 50, he didn't ask that question. He was therefore clear in his mind and he is now twisting. Now, Milord.
Only, Milord, there was Justice Chandran's query that even that pre-bid conference was struck off. But there was another clause under which pre-bid conference did take place. He participated, asked other questions.
Didn't ask this question. Now, Milord, kindly see. Sorry. Kindly turn to page 130 first. Your Lordship, nobody has shown this first. 130. Then I will go back to clause 5. What will supersede what? 130. Lord, I am in item 42. Your Lordship will have that file. I don't know, Milord. The solicitor's file. Whatever I am showing, Milord, is a part of the bid documents. Nothing is added, nothing is subtracted, nothing is given later. 130. See, my Lord, the last portion. This bid is governed. My Lord Chief Justice. Yeah. This bid is governed by the GTC conditions stipulated in the bid and the SLA. So it is governed, my Lord, by GTC and the SLA. It is SLA which has the scoring out. So kindly mark, my Lord. Governed by bid, GTC and the SLA, specified to this service as provided in the marketplace. However, in case of any condition specified in the GTC is contradicted by conditions in the SLA, then it will override the conditions of the GTC. SLA is therefore supreme. SLA, my Lord, has the scoring out right at the inception, which your Lordship may be pleased to see. Clause 5 is in GTC. The scoring out, my Lord, is in SLA.
No, clause 5 is not in GTC. Clause 5 is in ATC.
No. It's a GTC, page 17, Milord.
But we provide that if there is a conflict between.
I will come to that, yes. But please note, Milord, clause 5 is of GTC. Very broadly put, Milord, in that. Whatever is in 5, if it has a conflict with SLA, SLA will be supreme. Simple. Whatever is in GTC, Milord, will be inferior to the SLA. If that is so, whatever is in Milord page 17 will be inferior to the SLA. SLA has the scoring out and therefore there is no confusion. Straight and simple. Now come to page 17.
17.
Once yes, Milord, of the impugn judgment. Para 50. Clause 5 of the, page 17. Actually, Milord, the discussion should stop here itself. Clause 5 of the GTC states below. Now pause here, Milord, before I read. At page 130, SLA superior to GTC. Whatever is stated in the GTC will be subservient to the SLA. SLA has the scoring out. Therefore, we don't need to go further. SLA has the scoring out. So, Milord, why should we read, Milord, this? That's the error of the High Court in looking at this versus this versus this. That also I will demonstrate is wrong. But, Milord, the discussion according to me should stop at reading page 130 and para 5. Because if GTC is superseded, Milord, by SLA, SLA has the scoring out. My Lord, the Chief Justice asked a very important question last time. Was the scoring out, Milord, later introduced? Or was it a part of the bid? Yes, that's very important, Lord. If it is later, it will create confusion. But it is a part of the bid. Why? Milord, these are template agreements. They are meant to apply to hundreds of contracts. And therefore, Milord, you have to score out some, add something. For example, solicitor said, there is no STC in this case. There would be STC in another case. So it's a template agreement. Now, Milord, if anything which is stated in 5 is inferior to the SLA and SLA is to operate, Milord, see the scoring out once again at page 237. Then I will go back to Milord 5 again. No problem. Kindly turn to 237, Milord. 237, Milord, is a part of the SLA. And SLA starts at 231. My Lord may see 231. The Lordship will find SLA terms and conditions. My Lord, the Chief Justice have it. 231. This is the SLA. Now turn to 237. 4.6. Now the scoring out is not one line, my Lord. The entire clause going on till the next page is scored out.
Yes.
Next page. Now one more thing which is important is, my Lord. When you give an APS, in a given case, if you have to give APS, there have to be rules as to how long the APS will be valid, what will be the terms of the APS, right? All that is at the next page at 238, actually. Your Lordship will see these pages are on the top second line. If work is awarded with APS, so that means there can be, there may not be. It will be furnished in the form, validity will be 1 year or 90 days. The next para. Subsequent extension will be so much. The next.
That is all deleted according to you.
So all this is deleted. And therefore to insist for the High Court say give APS. No, APS can't be in a vacuum, Milord. It has to be with these clauses. Where are those clauses? Nothing is there. The error by the High Court is, Milord, not looking at page 130, that SLA will be without, Milord, the heart of the additional guarantee, which is this, to say in the air. Suppose the Lordship were to say.
Yes, now let me.
So, my Lord, just one more thing. I wanted to give a copy.
They're saying it's a mistake.
I have, my Lord, put those things from clause 5, if it, my Lord, is necessary. Though it is superseded by, my Lord, the page 130, I have just put it in a graphic form. My Lord may see this. Just see the graphic form. I have, my Lord, broken down clause 5. I have broken down clause 5 now. So, Lordship needn't see clause 5 now. As per clause 5, STC which doesn't exist and the SLA which has the scored out and SLA superior by virtue of page 130. The second part, my Lord, of clause 5, ATC which is additional performance security will be superior to GTC and STC does not exist. So your Lordship will find in either of the triangles that I have made, there is no supersession of the SLA. Now see the notes, my Lord, at the bottom. Hence, SLA is not superseded. Clause 4.6 to 237 additional performance completely struck off. 23.6 provides that additional will be given only if the bid is below 15, but it is struck off. And the GTC at page 130, which I have shown to your Lordship, also states that SLA will supersede the GTC.
Yes.
And that is why, my Lord, he never went and asked. And that is why he stopped at 13. Not the difference between 13 and 18% is 500 crores.
Why should I answer?
So he did not, my Lord, these are contemporaneous, my Lord, issues which show the state of mind of somebody. I don't need to ask, but I am not going to go below. When you suddenly realize, oh, that somebody's got it,
yes,
you then start a petition on 1st of July. And the next day, my Lord, the LOI is issued. Therefore, my Lord, and I repeat, my Lord, in order to save the contract, which I have got, the judge, my Lord, with great respect has said, the Chief Justice, that this could be for extraneous consideration. What is extraneous? My Lord, we are struggling. Struggling to find out.
Where the parties made personal capacity. Was anybody added in a personal capacity?
No, there is no argument. This is a 70-page judgment, and the judge said, oh, this could well be to exempt my client from PBS, and therefore it is affidavit.
Other parties or anything.
Yes, Dr. Singh.
And I said, and therefore, Lord,
yes,
I am willing to give that security.
Yes, that
Your Lordship will record.
Save
the contract, I will give it.
Now, my learned friends have argued at some length last time, and today I will take 5 minutes for this. Every concept and fact told to your Lordship, 90% is wrong. Just bear with me. The heart of the matter, where everything falls into place, is the hierarchy of this GTC, STC, ATC. Please note down my submission.
First, whether are you willing to give an undertaking?
That balance, in principle, of course, without the APS being additionally matched by us, if we are above 50, we don't have any APS, then we'll match the price, which is without the APS. Yes. But I will find out.
No, not without APS. Now we are learning.
No, everybody will follow the same APS. Yeah. But my matching will be of the price depending on whether I am above APS or below 50.
No, your matching will be minimum of what is offered by Dr. Rhodes.
Yes, of course.
Mr. Rhodes, sorry.
Yes, of course. That's
are you willing to give that undertaking?
But well, give me till Thursday or something that I have to find out. In principle, I think well, that's a fair point, and I've told them. But now just allow me to tell Lordship how unfair this is.
We will interfere. Take a chance. We'll interfere only.
I understand. Well,
the event you are willing to use such an undertaking.
I can't go beyond today instantly and saying this that I have.
No, you can ask your instituting counsel to ask your clients on telephone.
We are saying that if we are, as far as matching him is concerned, answer is yes. But obviously, if we are above the APS level, whatever it is, then we don't have to give APS. My learned friend was 18%.
18%. So whoever the minimum bidding will start at 18%.
That's all. That's the reserve price.
And whoever,
that's not the point.
One minute. Yes. And whoever is successful will have to give that ATS of.
I agree. I'm fully.
Whoever will be successful will give the ATS provided he is below 15%. Naturally, APS is 15%.
Yes, but now the bid will be below 15% only. It has to be not below 15%. But it has to be below 18% now.
No, my learned friends are mixing up two things. I didn't interrupt for 2 days last time. Today it's a running commentary. That one issue is the reserve price. We are all clear. The reserve price is the figure.
Now the reserve price
is there 18.7% minus.
It would be 18.7%.
Right. That's over now.
At plus ATS.
Right. No, plus 80. Now, on that figure we all bid. Right, Manoj? I bid above that. You can't have both, Manoj. APS will not arise. There is a conceptual error here. There is a conceptual error. APS to make sure that people like Mr. Rodgi, who went below 15%, will not walk away.
Now he is willing to give that 363 crores ATS.
Now your Lordship is having a rebid on this model of a reserve floor price. Floor price. Floor price.
Minimum price would be 18.3.
So that's a floor price.
Yes.
That has nothing to do with APS.
That has ATS also.
No, Manoj, that's a figure. Let's say it's 10 rupees.
Mr. Dr. Srini, we are willing to.
We will match the floor price and bid above that. And bid above that.
And plus ATS.
No, ATS will not arise, Manoj. Please appreciate.
This is a common sense question that anything below 15% has to be accompanied by ATS. And if it is 18% below, then the ATS will not only be there.
No, I came in without ATS. They allowed everybody above 15% to not give ATS. Mr. Rodgi artificially depressed his price.
We'll consider your case only if you are willing for minimum speed of 18.72% with an ATS.
That I've agreed with.
With ATS.
Well, I am unable to, there is some conceptual error. ATS will not arise. I'll tell you why.
How will it not arise if it is, if everybody is below 15%?
Yes.
Quoting more than 15% below. So he is quoting at 18%, you may quote at 19%, somebody may quote at 20%.
See, I bid above 15%, I bid 13% less. So I was kosher. I came to this court because he did not insist on that. It is his fault that he bid below 18 and got the condition waived. So my price was never culpable.
Okay, we'll set aside the order of the High Court. If you are not willing to give that undertaking.
Let me then take instruction with ATS also. This I have taken on the first part.
You take instruction by 4 o'clock, whether you are willing to have a minimum upset price of 18 point how much?
That I have agreed.
And also ATS.
Now, but let me now place the case. Very well, I'll take that. But allow me, because I am now only open now.
Okay. Yes.
That I hear a lordship of the first part, we have got instructions. Second part is the extra 337 crore, etc. We'll find out at tell lordship. Now, this is important. Lordship is just uninfluenced by all this. Just see the conceptual error, because lordship is being invited to make an error in the construction of a contract, which he admits his mistake. Twice he writes his mistake. And the benefit should go to Mr. Rothgi.
Yes, where does he admit that?
Yes, twice. The benefit should go to him. It's only written. Please take the latest affidavit. Take the latest affidavit. My lord has given, Mr. Mehta gave. Allow Mr. Mehta, allow me to place your mistake at least. You have been fair enough to write in English language.
Not scored in.
Yes.
That is the mistake.
This kind of benefit should go to Mr. Rothgi and not to have a retender, not to me. Come to para 7. He admits in black and white. Benefit should not come to me. I state that ATC. No, Chief Justice has got 7 minutes.
Yes.
I state that ATC starts at 62 and the part which is mistakenly retained is at 102. This mistake has occurred due to the copy paste from the earlier bid. This is, just see what the mistake is in a minute. Though this condition was decided to be deleted, which is reflected in the
now, therefore, we are saying that we are trying to put everybody on the same level.
I am on the mistake. See the next part, 8, para 8. However, mistakenly, the condition for additional performance securities accidentally remained at page 10. Twice he has said mistakenly. But leave this aside. Now, Maras, the first question is, what is the hierarchy? There are 4 concepts. Just write that down for a minute. Give me 2 minutes. GTC is the bottom of the hierarchy. STC, which includes SLA, is above GTC.
Where do we get STC includes SLA?
Yes, directly here itself, when I show the page. Whereas this is in this itself. Come to whereas page para 4 top. Para 4 top. In an individual case, there may or may not be STC, but the hierarchy of SLA is that of the STC. See the top of para, second page, para 5, top. Small Roman 4, my lord has got.
Yes.
Product track domain specific STC of particular service, including its SLA. Wherever SLA is there, the hierarchy is the including part of STC. This is what the High Court holds.
So you show us from the document.
Yes. This is this quotation.
No, you show us from the documents and record that SLA is a part of the STC.
Well, SLA is part of the STC is what is quoted by Mr. Mehta on the top here. Now the document itself is 200 of the first file, Mr. Mehta's file. This is no. I'm on this part. Go down.
In caliber.
This is in Balas. I'm sorry, page 17. It's quoted in 17. 17. It's quoted.
Of the judgment?
Yes, quoted.
Forget about the judgment. Show us the document.
No, this is the whole thing is quoted. Balas. Contracts clause 5. It gives you the whole clause.
We have already seen that.
So therefore,
show us from the record that SLA is a part of STC.
So just turn to para 5. Just see the structure, Balas.
Yeah, para 5 you already read that.
Following documents.
So para 5 you have already read from the.
No, shall be construed to be part of the contract generated through GEM, scope of supply, GTC, product service specific STC. That's number 3. That's my order number 3. 4. Product domain specific STC, including its SAL. With the STC goes the SAL. And then ATC comes on top. Now, my lords, on this finding, the finding here at paragraph 50 to 53, please read 51. Come to 51. What my learned friends called up is the SLA.
If you are willing to bid at 18 points so and so low, along with ATC, we will consider.
I appreciate.
Otherwise,
First part, second part will come back at 2 o'clock. Because then it is not necessary to argue.
2 o'clock only 1 minute. Whether you are agreeable for that or not.
Will just tell us should be agreeable or not.
Yes.
But just
If you are agreeable, we will permit everyone to participate in the tender.
Now I will just note one thing. Paragraph 51 to 54 says, but one finding, that if ATC is the highest, there is no deletion in ATC. It is not his case that there is deletion.
Yeah, appreciate that. Therefore,
That's right.
we are saying that we want to put everybody on a same level playing field.
That is a practical solution. I understand that. I am not objective to that. That's why I agreed to the first part.
Willing to file an undertaking that you will bid at least at 18 point so and so with an ATC, we will consider.
Goodbye, Lord.
Otherwise, we will say that.
Goodbye, Lord. Think of another thing also. This is virtually a tendering between us. This is what Lord is saying is a tendering between us. And whatever 4 or 5 other people, 9 people are there, I believe. 9 people are there.
Whoever is technically qualified is.
So Lordship will be having a retender within a smaller circuit of people. That's all. Otherwise, the retender would be all.
Only among
Qualified people.
Only among technically qualified persons.
Maybe it's
No, not to
make you better.
So that will save the time also. Otherwise, the retendering process may go on.
At least 6.
If you are willing for that, we'll
Keep one thing in mind, Manoj. You come and bid, Mr. Varodki bids at 18.
We'll withdraw that offer now. If you argue anything more, we'll withdraw that offer.
Very well.
We are only interested in the larger public interest. We are not interested in either your client nor Mr. Varodki's client.
I immediately.
No, but my lord, I will be at a disadvantage.
No, you are.
By virtue of this,
In a bidding, you may. It will happen. It will be the.
I have already thought of it.
It's the state who will be the best beneficiary.
I have already said that.
No, you were not willing to save rupees. The learned solicitor fairly agreed for that.
He was saving money, now he says he'll bid high.
Anyway, my lord, whatever the lordship.
Because for you, these thousands of crores of rupees may have been not relevant, but for the public spirited citizens and for the public, this money is more important. The public money, why should be permitted to be squandered away by? We don't know whether those observations made by the division bench are correct or not.
That's fine.
Good discharge kar do baat.
Right.
2 o'clock to 2, not more than 2 minutes.
No, only to record this.
No, there is one item, my lord.
Item 24.
My lord, item 24, it's only for my lord, appointment of the presiding arbitrator. We have appointed our arbitrator.
Yes,
I've done Friday.
Friday.
Thursday.
Item 31 is item 31.
Does-
There is a stay from more than 1.5 years. It's a fountain at Nagpur, my lord.
Today we can't hear it anything.
Today, I am not requesting next week.
Thursday.
Next week,
Next week.
This Thursday.
Okay, Lordships, may I mention item?
Thursday is a miscellaneous and since we are not traveling, we will be sitting for the entire day. We will take up all the matters.
Well, let's fast over matter.
May I mention item? May I mention
My
item?
lords, item 29, if my lords may.